afternoon and welcome to the Appellate Division, First Department. Every day I sit, I get a note letting me know how much time has been requested in argument time. And this is the largest amount of time I've ever had in the over 15 years I've been on the bench. So we have 8 hours of requested argument time. That would put us here till 10 p.m. tonight. So I'm going to say to you what I say every week. We are familiar with your case, your briefs, the record, usually more than you wish we were. So please ask for the time that you need, not the time that you want, so that I don't have to do it for you, okay? Please understand that the colleagues of yours who are at the end of the calendar really need you to do this, because otherwise they're going to be here for 4 hours while you talk. Okay, that being said, People versus Dominique Parrott. Okay.
Good afternoon. The people of us.
3 and 1 and 3. Thank you. That's a great start. Lurie versus New York City Department of Education.
Appellate request 8
Well, you're not listening. 4 and 1 and 4. C. Merriam is a submit. Allen versus Thompson.
Good morning, Your Honors. For the appellate, Christopher Thompson, 5 and 2, please.
Okay.
Good afternoon. For respondent, 3 minutes.
5 and 2 and 3. I like that confidence. Mills versus Santos.
Request 3 and 1, Your Honor.
Okay. 3 and 1 and 4. People versus Irving Talavera. Submitted. People versus Avis Ruiz.
4 and 1, Your Honor.
Okay. 4 and 1 and 3. Rosenblum versus City of New York.
All appellants respondents.
Okay.
On behalf of the city, 5 and 1.
Okay. Okay.
Plaintiff, 5 and 1.
That's exactly what I had for each of you, 5 and 1. Evans versus Punter. Good afternoon.
Request 5 and 1, but I may use less than 5.
Perfect. Okay.
Good afternoon. Respondents, Harry and Hunter Rucker are requesting 4 minutes.
Okay. 5 and 1, 4 and 4. Priestley versus New York City Housing Authority.
7.
Stand up.
7 and 3.
Okay, you weren't listening either. Go ahead.
Respondent request 3 minutes.
4 and 1 and 3. People versus Marcus Turner.
Defendant appellant requests 4 and 2, Your Honor.
Perfect. 4 and 2 and 4. People versus Nelson Gago. Okay. 5 and 1 and 5. Rubin versus EFP Rottenberg LLP.
Respondent, 4 and 1.
Okay, I think you need a little more time. Go ahead.
Appellate respondent, 4 and 1.
Okay. Let's do 5 and 1 and 5 and 1. Okay? MIC General Insurance versus Eckert.
On the appellant, 3 and 1, Your Honor.
Okay?
For respondent Jacob Sanchez, please.
3 and 1 and 4. Omansky versus 300-302 East 119th Street.
Appellate, 5 and 2.
Okay?
Respondent, 4, please, Your Honor.
All right?
Respondent agency management 4 and Gina Torres, 3 minutes, Your Honor.
Okay, let's do 5 and 2, 4 and 3. People versus Emmanuel Ford.
Request 5 and 2, Your Honor.
Okay?
Good afternoon, Your Honor. People request 5.
5 and 1 and 5. Whitley versus Lee.
Good afternoon, appellate request 3 and 1.
Okay?
4 minutes for the respondent.
3 and 1 and 4. Forrester versus 640 Park Avenue Court. Okay. 3 and 1 and 3. People versus Kashawn Bowers. Submit. Stuckey versus City of New York. Submit. First case on the calendar. People versus Dominique Parrott.
Good afternoon, Your Honors. May
Good
it please
afternoon.
the court. Desiree Sheridan for appellant Dominique Parrott. I just first wanted to acknowledge in the people's brief that they did actually consent to our issue regarding the vacator of Mr. Parrott's trespass conviction and sentence, since he did not allocute to that charge or plead guilty. So I wanted to start with that. And then I wanted to move on to the waiver issue in this case.
All right.
And submit to you that because the waiver here was not knowing, intelligent, and voluntary, that Mr. Parrott's remaining claim is still reviewable by this court. I would start out by saying that this waiver really came on the heels of the court's discussion of the rights Mr. Parrott was giving up by pleading guilty, and there was really not any sort of emphasis on the distinction between the two. It was also a very short colloquy that the court
Is
gave.
there any required colloquy according to the Court of Appeals?
I mean, there's no required colloquy, but you
And
have to.
isn't it a question of the totality of the record? And what's wrong with the totality of the record here?
Yes, it is a question of the totality of the record, and in this particular circumstance, given Mr. Parrott's background with his mental health issues and maybe his comprehension issues, this was a very short, very superficial colloquy, and I know that my adversary relies heavily on what they termed an exemplary written waiver, but I think it should be noted that Mr. Parrott was never asked if he had read the written waiver, if he understood the contents of the written waiver. In fact, he was told to sign the written waiver, essentially. So I don't think that you can rely on what was in that written waiver to sort of buttress anything that the court said, which was not very much. So, you know, they never told him that there were issues that would survive the appeal waiver. They never asked him if he had discussed the appeal waiver with his attorney. They never talked to his attorney, and knowing the issues that Mr. Parrott had, said, did you discuss these issues with your client, or did you discuss this?
We have a lot of litigants who are sentenced to pleas in criminal court that have mental health issues that are recorded and on the record. Are you saying that there is a new standard that this court should employ for people with that background? Because we have no case law that says that, correct?
Correct. And I wouldn't call it a new standard. I would say that you're in keeping with the rule or with the instruction that you have to look at the totality of the circumstances, and the validity of the appeal waiver has to be examined against the backdrop of your particular client.
So again, I ask you, are you suggesting that there is a new standard that needs to be applied to someone who has a mental health history? Because if that's the case, then that standard is going to have to be employed on a great many cases.
I wouldn't call it a new standard, but I would say you have to consider this appellant's situation when you determine whether this appeal waiver was knowing, intelligent, and
And
voluntary.
what case stands for that proposition?
Well, the cases that say that the court has to ensure that the appeal waiver is knowing, intelligent, and voluntary.
Yes, but there's no case that says there's a higher standard that needs to be employed for someone who has any kind of history with mental health issues.
Right,
Which
it's
is
not-
what you are suggesting.
No, but I'm not suggesting that, but I'm suggesting what might be considered knowing, intelligent, and voluntary for someone who doesn't have these issues might not be the same for somebody who does have those issues. So it's the same standard, but you're
It's
applying.
not the same standard then.
But
You can't say that out of both sides of this argument and say that it's the same thing. It's not.
But it
You're
changes.
suggesting there is a higher standard that has to be employed for someone who has any kind of mental health history. And as I said before, that would be about 80% of the litigants who come before the criminal court.
Correct. I see what you're saying, but I guess what I'm trying to say is that you have to make sure it was knowing, intelligent, and voluntary, and then you have to look at your defendant and say, was this knowing, intelligent, and voluntary for him? And in this case, I would submit that it was not.
Thank you. Counsel?
Good afternoon, Your Honors. May it please the Court. Matthew Osnos on behalf of the people. Defendant's appeal waiver was knowing, voluntary, and intelligently made, and therefore is...
Is there anything in the record that reflects that the court confirmed with defendant that he understood the written waiver? Was that question asked?
The court didn't ask about the written waiver specifically. However, it did ask whether he had spoken with his counsel about the guilty plea as a whole, which he confirmed that he did, and he confirmed that he was
But
satisfied.
talking about the guilty plea is not the same thing as talking about the waiver. And insofar as Thomas says that this court has to consider the totality, so both the written waiver and the oral colloquy, if the court has not ensured that the defendant has read or had the waiver explained to him, how do we know?
Well, I agree with you that it would have been better had the court used more precise language to ensure that defendant had read the waiver with his attorney. However, defendant was standing in open court with his attorney beside him. He was encouraged to ask any questions about the written waiver to the judge, which he did not. And so the reasonable inference...
Is that the way that we look at these waivers, or do we look at it from the defendant's perspective as to whether or not he was aware and knew, voluntary, all of those things?
Sure. You look at the totality of the circumstances, and here the court conducted a careful colloquy. It went through all of defendant's trial rights, then turned to the appellate
How did the
rights.
court explain to the defendant that his appellate rights were separate and distinct from the trial rights that he was waiving?
Right. So the court first ran through all of the normal trial rights that defendant was giving up. Then the court said, now ordinarily a defendant has a right to appeal. He then said, but in this case, you're being asked to waive that right. He then went through the contours of the appellate process and told defendant that by waiving his right to appeal, he would be waiving certain claims like an excessive sentence claim here. Your Honor,
Did the court explain to the defendant what appellate rights survived? And does the court need to do that?
the court did not do that here. However, the written waiver does get into further detail
The
about
written
which
waiver
rights.
that no one confirmed that he understood?
Although he was standing by his attorney, yes. However, I don't believe the court needs to address any particular litany as to what rights survive an appeal. Beyond that, though, even if you were to find the appellate waiver was insufficient here, the excessive sentence claim has no merit. Defendant's term of 5 years post-release supervision was eminently reasonable, given the seriousness of the crime he committed, his lengthy criminal history and high risk of recidivism, and the fact that he didn't take responsibility for absconding from the mental health program, not once, but twice. On this record, there's no reason to give appellant any more leniency than he's already been granted.
And how would the Less is More Act affect this defendant?
With good behavior, he could get the exact relief that he's seeking, a reduction from 5 years post-release supervision to 2.5 years post-release supervision. And if there are no further questions, I ask that you affirm. Thank you.
Thank you so much. 1 minute, counsel.
I just wanted to briefly go back to the waiver issue and point out again, which I said in my brief, the fact that Mr. Parrott discussed the plea with his attorney didn't necessarily mean he also discussed the appeal waiver. And again, there were no questions posed to him before he was told to sign the appeal waiver. And again, you would have to look at the totality of the circumstances, which I submit do not show that this waiver was knowing, intelligent.
Counsel, notwithstanding the validity or not of the waiver, it is true that the people did concede that the conviction of criminal trespass has to be vacated since the defendant never entered a guilty plea to that charge. Is that correct?
Yes, that is correct. I did want to point that out. The people did acknowledge that he never allocuted and never actually pled guilty to that. So we would also ask, as we asked in our brief, for that to be vacated. And if there are no further questions, I'll rest on my brief.
Thank you so much. Have a good night. Matter of Amanda Lurie versus New York City Department of Education. You can come up to the mic. You may proceed.
Good afternoon, Justices. Mitchell Rutkin for the appellant Amanda Lurie. I will do my best to finish quicker than I asked for. It's been a very long time since I've done this, and I may be overestimating how long I need. This is the issues here that we are asking the court to look at are both the the application of the arbitrary and capricious standard under Article 78, as well as the way in which this case was analyzed pursuant to the CPLR 3211 in a motion to dismiss. Had this case come at the end of a full Article 78 proceeding and the court reached this conclusion, we would still disagree and maybe even appeal, but our disagreement would be much less vociferous. We feel that there are very clear parts of the record here that, when looked at in the light most favorable to the respondent to that motion, make it nearly impossible to reach the conclusion.
You realize that we are bound by the Article 78 standard.
Yes.
Right? And we cannot, even if we disagree with the Article 78 finding, we can't overturn it unless it's a very high standard. And so my simple question to you is, how do we reach that very high standard here?
We think you reach that very high standard if there was wrongdoing on the part of the agency. And so one of the things that this decision is doing is it's separating out the person in the agency who ultimately signed the termination letter from everyone else in the agency who is accused of wrongdoing here.
Was there an investigation that took place, and was that the basis for the discipline and the arbitration finding?
So there was no arbitration.
The question was there an investigation prior to the arbitration?
There was absolutely an investigation. And the issue with that investigation is that investigation was intentionally left out, according to our client and the affidavits of the people who were part of that investigation, intentionally left out interviews and information that would be exculpatory for our client, that literally said, this isn't true.
Did your client have an opportunity, or was she invited to, I guess, address the findings or meet with the decision makers? And did she take that opportunity?
She was given a short opportunity to do so.
Did she take the opportunity, short or not?
She did not at the time, for various reasons, part of which was just her health situation, but also because she didn't have the information that she would later be able to get with more time. So for instance, her direct supervisor, who said none of these allegations in this investigation are true, and in fact,
Her direct supervisor was likewise implicated in the issue. Okay, so I mean, come on. If her supervisor allowed her to sign for time not spent in the office, and the powers that be determined that that was inappropriate, her supervisor is in as much in the hook as she is.
yes.
So it seems to me that the arbitrator was certainly well within their rights to consider that in determining how much weight to place on that testimony.
So again, I mean, I think that is something that places weight, but that was not the only person who gave testimony who was involved here that said, actually, there was a higher up who directed the investigator not to put in information that would be exculpatory. There were people.
Like what? What exculpatory information is there from submitting a request for payment of time worked that investigation reveals wasn't worked?
Yeah, so if you look at the affidavit of Kleinhandler and Grohl, what they both say is that, she was actually approved for all this time. And in fact, remember, this was during COVID. Many of these places were closed. Many people working remotely.
Not all of it was during COVID, was it?
The majority of it was, yeah.
I thought that some of it started before COVID. Am I wrong? I have a lot of cases on today, so I might be off on the dates.
I believe it starts at the second half of the 2019
So that's before COVID.
But the vast majority of it is during COVID.
Okay.
I also want to speak just a second to your point about her supervisor being, also getting a determination of wrongdoing here. This also, we think, goes to the arbitrary and capricious standard, right? She doesn't get fired when this report, this investigative report first comes out. She gets promoted. 5 months go by, and it's only after there's articles in the New York Post that are bringing this to light that she gets fired. And so the
Does that make it right? Does the fact that she's not fired immediately somehow change the facts that underlie the basis for the firing?
well, I think it goes to the reasoning of the Department of Education, right?
And we can talk about that on your rebuttal.
Thank you.
All right.
Good afternoon. May it please the court. Chloe Moon on behalf of DOE.
Counsel, it is hard to reconcile that after all these findings that she's promoted.
Yes, Your Honor, and I can't speak specifically to DOE's process in...
Isn't that in itself evidence of it being arbitrary and capricious?
No, Your Honor.
So how do you promote someone and then turn around and fire them when you have all the facts in front of you? Nothing's changed.
Yes, Your Honor. The termination letter was written by Grohl in his affidavit that the petitioner herself submitted. He said he didn't find out about the report until late July and then had a meeting with her in August. So the timeline from his perspective, the person who was making the decision, was actually quite quick. I can't explain.
Are you
it's not in the record.
that they were unaware that she was under investigate? Come on.
No, and I can't explain it. It's not in the record. But what I can say is that the decision makers found out about it in late July, according to petitioner and petitioner's evidence, and set up a meeting with her in August, which she did not take the opportunity to actually participate in. I'd like to quickly talk about the affidavits that my colleague has brought up. First, as this court knows, affidavits that are presented at the summary at Supreme Court level is not something that's reviewable because of the agency. It wasn't before the agency. But even if this court were to review them, we don't think they actually help her. Kleinhandler affidavit doesn't say much more than what she had already been interviewed and what was already in the report and the OSI findings, and that's at R195. And then the Grohl testimony says that Kleinhandler wasn't interviewed as a part of the report, but she was, and that's there at R195. So there's not the evidence of bad faith that my adversary seems to think there is. Here, what we have is substantiated findings of time theft and fraud, including 23 instances of discrepancies between the cyber shift and her shared personal calendar. At most, those affidavits are talking about the shared office calendar. They're not talking about how she failed to also include that time off in the cyber shift. So none of those actually go to the heart of what the problem was here, which were those 23 discrepancies that we have documentary evidence of from the OSI findings. Unless this court has any other further questions, we ask this court to affirm.
Thank you.
Thank you.
Thank you, Justice.
I'm giving you her extra time left over.
That's okay. I just want to clarify a couple of things in the record because I think it's important. Mr. Grohl, who gives this affidavit, which is on page 83 of the record, actually says that he became aware of the OSI report on March 16th, 2023. He knew about it from the beginning before the promotion for my client. He also states, and I think this is critical, that not only was he aware that Ms. Kleinhandler had given an interview with OSI, but that he was aware that the deputy director had told the OSI investigator not to include much of that information in the report. So this was something that was known throughout the DOE in their investigation, that they were not presenting the full breadth of the evidence in this report. And again, if this report's going to be relied on as, well, look, they have this report so they can terminate her, and then we're just going to ignore the fact that there were all these discrepancies with the report. You know, we have this situation where we're basically telling these agencies.
Is there any evidence that your client puts forth to contradict the claim of theft of time, theft of services?
Yeah, so both in her affidavit and her,
Outside of, I was given permission to do it.
well, she has affidavits from people who say she was a very good employee and did not miss work, But I think a more critical thing to understand here is that,
There were a bunch of employees who said they never saw her.
yeah, but some of those employees, including Ms. Theo, who gave that testimony to the investigator, also said that she only worked with her for 7 weeks and was told to give this information to the investigator and was coached to say these things, but she actually didn't even work at the site that Miss Laurie would have attended. So there's all these discrepancies, and again, if you're taking the information, if you're taking the facts in the light most favorable to the respondent, then you can go through the Article 78 process and come to these conclusions at the end, not on a motion to dismiss.
Is that the standard here on an Article 78?
On a motion to
Light
dismiss.
most favorable to the, okay,
I believe so.
all right.
Thank you.
Thank you. Allen versus Thompson. You may proceed.
Thank you, and good afternoon, Your Honors. Thank you for this opportunity to be heard. May it please the court, my name is Christopher Thompson. I'm the appellant in this case, and I seek reversal of the lower court's denial of my motion for summary judgment. I'd like to just focus on 2 issues in my brief. First is whether I was required to produce an expert report. I think when we look at the specifics of this case, you have a situation where the plaintiff was directed in 6 different orders to produce an expert report and did not. The requirement for me to produce an expert report,
But this was your motion for summary judgment?
I understand that.
And when you're the person making that motion for summary judgment, you have a burden to meet yourself. And in most legal malpractice cases, expert affidavit is part of that burden. Did you submit such an affidavit?
So the argument I would make with respect to that is twofold. First, as
So the answer is no, I didn't submit an expert affidavit, and let me tell you why that's okay.
I'll do it your way.
Okay.
Thank you, Your Honor. So the first thing I would say with respect to that is that the expert report from me was conditioned on plaintiff filing an expert report. That's in the 6 orders. But setting that aside, one thing we do have in this case is and it's in the record, is the determination from the grievance committee that there was no disciplinary conduct that required any further steps from the grievance committee. And we have that in the record. The second thing, and so I would ask the court to almost look at that as an expert assessment of what was going on, because they made that determination. And really that's where we stand. But Your Honor did something very practical when you called the calendar. You said, we're not going to be here for 8 hours. Everybody needs to focus on their points. Very practical. So let's look at this case practically for 1 second.
Yeah, how about you focus on this case, because I am not sidetracked by all this talk that's telling me nothing.
So Judge, what I would say is this. That element of plaintiff's case is not going to be shown because they don't have an expert. So we're going to impanel a jury, let them put on their case, and then move to dismiss?
You moved for summary judgment.
I know that.
You have the burden. So how did you meet your burden? You don't get to move for summary judgment and say, he doesn't have any evidence. That's not how it works.
Judge, I understand, and I read the cases, and I felt that this was an exception, and I feel if we looked at Frankel v. Vernon, that's where the court sits on this point. I also think that the Court of Appeals, when it made its decision in Andre v. Pomeroy, which is cited in my brief, points that out as well. But I'll move on from that point and just move to my second point, if I may, which was with respect to the breach of contract claim.
I don't think you even covered the first point, but go ahead.
Okay. Well, to the extent I didn't, Your Honor, I think it's in my brief.
Okay.
And I'm happy to
Go ahead.
answer
Go
any
to your
questions you
second
have.
point.
With respect to the second point, Your Honor, on the breach of contract, the breach of contract claim is stated in the complaint as for reimbursement of the legal fees that the plaintiff paid me in the federal action. She admits that she paid me absolutely nothing, not a single penny. So I think that I don't see how you can have a breach of contract under that fact. The second thing I would say is that
There
the,
certainly wouldn't be any damages.
yes, thank you, Judge. So the second point with respect to this is then the lower court seems to focus on the back and forth, which would be question of fact, of whether or not there was an agreement to seal the action in federal court. So there is no retainer agreement, there is no contract. It's he said, she said, literally, which I get.
But eventually, the federal court did unseal the documents based upon a motion made by not you or the other side, made by someone else. So the federal court already unsealed that. So that's not really a big problem. I wondered about the issue with the actual agreement that you made the changes to. That was what was concerning me.
So, and that I believe winds up as a question of fact if the court's not persuaded that on the issue of the expert report. And again, I think we wind up getting to a jury and the case getting dismissed because they can't prove that element, and that's a waste of everyone's time. But if that's
So
what this,
did you contest that you typed up the agreement and changed 2 words on it without telling
so Judge,
your client
of
that?
course, yeah, of course, it's absolutely untrue that that's what happened. And
So she typed it up?
so
Did she type it up or did you provide it to her?
I did not provide it to her. That document originally came to her the day she was terminated from her employer at her place of
Except that the
business.
document was changed.
That's right. And
So who did the changing?
so I don't,
Since it was your advice
yeah,
to change 2 words,
that's right.
right?
So
And so who provided her with the changed document?
So I think
This is a simple, yes, I did it, or I don't know.
I did not make that change, and I don't know how she managed to make that change.
Okay.
But the affidavit
Well, you don't know whether she made that change. All you can say is I didn't make that
the
change.
affidavit that she signed says that she caused that change to be made. That's what it says.
But you prepared that affidavit, right?
Did. Because the discussion was that, and again, if we get to a trial, we'll deal with that, but the discussion was very simple. You cannot move forward. You cannot go to first base here and go after your claims for discrimination, age discrimination, et cetera, with that language. If the language is changed and they agree, and we have the testimony that she put a stickum on it and she initialed every page, et cetera, if they accept that
The
change.
testimony
then-
was that stickum was at your advice. But we can address that on rebuttal.
Okay, thank you.
May it please the court, Tyler Fear for the respondent. We ask the court to affirm Supreme Court's denial of appellant's motion for summary judgment. Appellant, as the movant, bared the initial prima facie burden to establish that he did not breach the standard of care owed to respondent. Either by expert testimony or in his affidavit, he did not provide Supreme Court with any evidence that he conformed with the standard of care owed to the respondent.
Just now when your adversary put forth his position, he indicated that there was some sort of disciplinary proceeding that said that he did nothing wrong. Is that enough? Or was that presented to the court below?
Well, yes, a grievance committee issued a letter of advisement to the appellant. That is in the record. I don't think that's enough to demonstrate that he conformed with the standard of care. Instead, appellant solely points to supposed gaps in respondent's evidence, which courts have routinely held is not sufficient to meet his prima facie burden. I'd like to direct the court to a case decided by the Second Department in February of last year. We didn't include this in our brief, but it's Kliger Weiss Infosystems, 235-83rd 857. It is a factually similar case. The second department held that the defendant failed to meet his initial prima facie burden solely by pointing out that the plaintiff did not provide expert witness testimony.
I mean, is it true that the court directed you to produce an expert report numerous times that was not produced?
Well, there are status conference orders that provide us the opportunity to provide expert reports.
The opportunity? That's interesting. I love that. Compliance conferences, orders don't provide you an opportunity. They provide you an order and direct you to provide items. Don't play games here.
Yes, Your Honor. But
Seeing as I drafted the Bronx Compliance Conference Order, I know exactly what I'm talking about.
well, notwithstanding that we don't have an expert report, if the court affirms, then respondents may still prevail at trial because there are exceptions to the general rule that expert witness testimony is required to prove a breach of the standard of care.
You wish to be heard on the breach of contract claim?
Yes, Your Honor. It's well settled that a cause of action for breach of contract is not duplicative of a malpractice cause of action when there's a specific promise to perform and no performance. There's a material issue of fact that
Are the
appellant-
damages the same for this alleged breach of contract as is the damage from the alleged malpractice the same as the damage of the breach of contract? And isn't that one of the issues we have to consider in determining whether it's duplicative?
I don't think that it's duplicative damages. In this case, there's material issues of fact whether appellant agreed to attempt to seal that federal court action. He did not do so. Respondent had to hire a different attorney to seal that action.
But now that the records were unsealed because of somebody else's motion before the federal court, are there really any damages that you can get from that, even if, in fact, he didn't do what he was supposed to allegedly do?
Yes, because she still had to retain a different attorney to attempt to seal that action.
Now, a question. Was the request to seal the action a part of the negotiation for settling the action at the inception? Or was this an afterthought after the settlement and the negative impact of the settlement not being sealed being felt upon your client?
Yes, it wouldn't have been at the initial retainment of the appellant. It would have been later on when that federal court action was initiated, and then she faced the counterclaims for fraud.
Thank you. All right.
Thank you, Your Honors.
Counsel?
Thank you again, Your Honors. Just initially, I think it would be improper to have this case cited by counsel as a recent decision without having provided a copy to the court and to me prior to argument.
Not that it would prevent this court from doing its own research and finding that case anyway, but I take your point. Go ahead.
Thank you, Your Honor. And I do agree with the court's point that it wasn't an opportunity to provide an expert's report. In fact, it was ordered, and as I started to say, the direction for me to provide one was contingent on their doing one. I heard everything else the court said on that. but I
And
want to
that's okay. The problem is you move for summary judgment. And once you move for summary judgment, regardless of the orders of the court, there is a requirement of evidence to meet. And you didn't do that here.
I understand what the court's saying, and just the last 2 points I would make. I do think that it's duplicative. All of the alleged damages have to do with this inability for a decade and a half to get gainful employment, even though the facts.
Well, isn't the need to hire another attorney and pay attorney's fees for someone else to get them to do what you didn't do, isn't that an additional damage that is separate and apart from what would have normally been the damage?
Judge,
To me.
I would agree 1,000%, but that was never disclosed in any of the deposition testimony. This is the first time I'm hearing it, that she hired another attorney to do something in the federal court. It's not in the record.
Got it.
And this isn't the first time they did that, because the first time I brought a case up on appeal, they came here and told this court that I had been paid thousands and thousands of dollars. It wasn't true, and she testified to that. This is someone I knew for probably 20 years. I was trying to help, and here I am, and I'll continue to have to defend
No
myself.
deed goes unpunished, my friend.
Yeah, I judge.
Have a good
100%.
day. Thank you. We're done.
Okay.
Thank you.
Thank you. Have a great day.
Mills versus Santos. You may proceed.
Thank you, Your Honor. Good afternoon, Your Honors. Jason Levine for the defendant's appellants. We submit that the court's denial of the defendant's motion to disqualify plaintiff's counsel constituted an improvident exercise of
Why
discretion.
did it take you so long? Look, I agree with you 100% that there's no question that on the facts here, this should not have happened, right? There's clearly a potential conflict. But then you get on the case and you wait 3 years to move. Seems like that boat has sailed.
I would submit otherwise, Your Honor. Yes, there certainly was a delay. However,
I would
3
just add-
years.
And I would just add, this was after you had already moved for a summary judgment, right?
I believe that's correct, Your Honor. But what we have here, though, is that the information that was relayed from the plaintiff's counsel regarding the representation, the letter of representation,
And it
which
took
took place
you
in
3 years to figure that out?
Well, that was
Come
to-
on. Look, the problem you have is the delay. 3 years. The case law cuts you off at 2.
Right. But I would submit, though, Your Honor, this information was imparted to the defendant's insurance company, not to defense counsel directly. And I believe the defense counsel in the supporting affirmation says at the time they made the motion that the information had just come to them regarding the representation. Now, granted,
Was there any confidential information that counsel received from Santos?
there's nothing in the record that indicates that any type of confidential information.
And there was there was only a short period of time, I think a couple months, that the law firm represented both Mills and Santos. And there's no allegation, as you say, there's nothing in the record that anything was disclosed. I mean, me, who sat in the motor vehicle part for several years in Manhattan, can't believe that there was a law firm out there that would represent both the passenger and the driver in a motor vehicle accident. Of course, they did provide this notice of potential conflict. I still was shocked by it. But 3 years? Really?
I'll answer the two questions posed separately about, with respect to the confidential information, that's not dispositive, where it's either or under the Pellegrino case from this court with respect to whether or not the representation is substantially related. Here it is because it arises out of the same motor vehicle accident.
Right.
There's no dispute about that. Now, again, just to get back to this delay, and again, it was a short period of time, but again, we would submit that's not dispositive under the circumstances here of representing a driver and a passenger where the conflict was patent on its face from the beginning.
I said that.
Right, the police report says.
Our problem is your 3-year delay.
Right,
And there's no good explanation for it, counsel. None.
even if
This
there is.
nonsense of, oh, he just found out about it. Come on.
Well, I could just say, that
Come on. Was he asleep?
if I could just, before I'm finished, with respect to the delay, though, here, though it wasn't done, I would submit under the record here, is a strategic advantage. At the time they made the motion, discovery was still going on, a note of issue had not
Which
been
is
filed.
why it should have been done right away. But we'll hear you on rebuttal and you can say it again.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. The delay is dispositive. The case law is dispositive. Under matter of coast, 2 years.
Your client should have never, your people should have never done this. Never.
I'm not disagreeing with
Okay?
you. I'm not disagreeing
You
with you.
can't represent the driver and the passenger's hurt. Hello? That is like basic 101 conflict.
And, Your Honor, I think that our client did it right after they did it wrong, if that's possible. Within 3 months, they realized the conflict, and
They should have realized it in drafting the
Well, I
darn
mean,
thing.
I think they realized it before because this notice of potential, and I put that in quotes, even though it's not their potential conflict of interest and waiver of conflict-free counsel, was quite extensive and anticipated exactly what happened. I still can't believe they did it, but at least they came up with a pretty comprehensive waiver, which with both the plaintiff
Right,
and Santos
I'm
signed.
not suggesting that their explanation was appropriate, that they believed or they leaned on the passengers relaying that they thought the other car was fully at fault. I'm not suggesting that that's reason enough, although it is in the consent. But I think that the delay is significant here, and I think it is strategic because I'm not sure what my adversary means by by plaintiff's counsel just telling the carrier 2 days later about representing Santos. 3 years after plaintiff commenced suit, they made this motion to disqualify. So they knew this for 3 years at least, and 4 years after they discontinued. I mean, they interposed an answer in 2021.
I think what your adversary was saying as he was getting ready to sit down is that discovery was still ongoing when he made the motion for summary judgment, and the note of issue had not been filed. Does that matter?
What was clear was the notice of appearance for the plaintiff and a potential defendant were the same.
That's true, and I'm not sure if first of all, it's not in the record what the stage of discovery was, so I can't speak to that because I don't know, and I don't know how my adversary knows unless he's the attorney of record, but it's not in the record as to what stage the discovery was at. Our position is that there is an inference of a tactical advantage when summary judgment motion has been made. Now we're 3 years after the summons and complaint, years after they interposed an answer, years after Santos now has a new attorney, and there isn't any information on this record that would show that there was anything in the 3-month representation, as awful as it may be that they did that there is anything that was imparted that would prejudice or penalize or have, an appearance of impropriety, whereby now at this stage of the litigation, the plaintiff would now have to get a new attorney. Whereas we're in the stage, even if we are still in discovery, where they'd have to get a new attorney and step in at this late stage. So for those reasons, I'd ask this court to affirm. Thank you.
Thank you. You have one?
Thank you, Your Honor. Again, just very briefly on this delay again. Granted, a lot of these motions are frequently made to gain the advantage at trial. Right? These motions get made on the eve of trial in a clear tactic to throw off and get the case off the trial calendar to get a new plaintiff's attorney involved. That wasn't the case here. Again, there was no the case. I don't even think it's still on the trial calendar. The case, so there was no tactical advantage sought by virtue of the delay here that in making this motion. And again, unless the court has any further questions, we'll rest on the arguments in our brief. Thank you.
People versus Avis Ruiz. You may proceed.
Good afternoon, Your Honors. After I won Terrell in the Court of Appeals, I thought we had the holy grail as it came to plea appeal convictions. But little more than 3 months later, in Federico Perez, this court said, not so fast, it's distinguishable, and limited the scope of Terrell. I took Perez up to the Court of Appeals, I lost, and the Court of Appeals adopted this court's rationale in Perez and Canseco. Today, the shoe is on the other foot. The people are coming in today and saying that Rios definitively resolves this case. It does not. This court has the opportunity in Mr. Ruiz's case to distinguish Rios and indicate that it is not as all-encompassing as the people are suggesting. Yes, it absolutely covers the statements that my client made, but what we're talking about here is what's contained in the pre-sentence report. The pre-sentence report contains an account of the case based on the district attorney's files that does not reach the standard of an attempted rape based on Maboubian. And this was not something that my client had. He does not get the pre-sentence report. At most, counsel reviewed it at the time of sentencing. So he had no opportunity to challenge it and says, wait a second, this isn't an attempted rape.
Wait, you're saying that when his attorney receives the pre-sentence report, he doesn't read it thoroughly?
All he says on the record is, I viewed it. That is exactly what he said at sentencing. I viewed it. There's nothing to indicate that my client, Mr. Ruiz, looked at it. He's the one who has to make the motion to withdraw his plea, not the counsel in this particular case. Mr. Ruiz had no knowledge.
Wait. It is attorneys who guide the cases, not the defendants. I mean, a defendant certainly has a right to ask his attorney for X, Y, or Z, etc., of course. But it's not the defendant who guides it. So
But
I'm trying to understand what your argument is, because the defendant is not an attorney.
Right.
So
But the cases all
the
indicate.
fact that he reads it doesn't mean he's going to understand the legal import of it.
That's true, but he also doesn't know what's contained within
Well,
it.
then
And-
I'm concerned, I don't know, was there a 440 motion arguing ineffective assistance of counsel?
There is no 440 motion.
And outside of what you're saying, was there anything in the record, on the record, that indicates that your client had raised the defense?
No, but there's nothing. This would be what's contained in the pre-sentence report as the account of the offense comes from the district attorney's files. And the district attorney's files account of what occurred in this case does not establish an attempted rape. It establishes something less than that. My client did not see the pre-sentence report. It is not given to the client. Mr. Ruiz didn't get to see this. If he had and read it,
Again, you keep saying that, but Mr. Ruiz ain't a lawyer.
I know.
So it doesn't matter. Other than him saying, I agree with that statement, it's the lawyer who has to do something with what's in this report.
But again,
So the fact that the defendant doesn't see it, I don't understand the legal import that you are attaching to that.
the legal import that I'm attaching is that the cases say that the defendant has to move to withdraw his plea, that they're putting an affirmative obligation on the client.
And you're saying that by seeing this report, the defendant would have known he should move to withdraw his plea. Come on.
He would have at least had the opportunity.
Come
to make
on.
that determination.
You're talking about a lawyer has to make that assessment.
Counsel-
And you're making the argument that we should make this determination based on what a defendant who's not an attorney would think?
No.
Let my colleague ask you a question, and then if you want to say something to me, by all means.
It's your position that the pre-sentence report, that the facts contained therein have to establish all the elements of the crime?
Yes, that it comes less.
Where does that come from?
Where does that come from? It comes from the listing of the offense, the details of the offense.
What case says that? What case
statute.
says?
What?
Or statute says
No,
that?
what we're talking.
No. You are saying
there-
the pre-sentence report doesn't have all the elements of the crime. What statutory ground is there to say that that is required?
In more than 40 years coming before this bench, I have never seen a situation like this where
Counsel,
there
where-
is no case.
Counsel,
You're
where-
absolutely correct, Your
Counsel,
Honor.
where this mostly comes up is when there's something exculpatory made in the pre-sentence report. I didn't do it, or I had a self-defense, or my attorney forced me to plead. Right? That's a different situation. But now you're adding an extra component that the pre-sentence report, in essence, has to be legally sufficient in that it has to have facts that establish all the elements of the crime, and I don't know where that comes from.
No, what we're
You're equating it with a grand jury
No.
presentation.
What we're asking is that the court, when it takes a look at this, does the court have an obligation to make an inquiry?
Well, do we know whether the court even looked at this pre-sentence report?
The court has to look at the pre-sentence report
It's
before.
supposed to look at the pre-sentence report, but what is it looking for? Is it looking for each and every element of the crime's charge, or is it looking for exculpatory evidence?
It's looking for everything. It's supposed to make a comprehensive review of it to make sure that the sentence that was agreed upon.
So
is the
even if the
appropriate
court
sentence.
looked at it and the court realized, oh, there's an element missing, so what?
then it's our position that the court should have at least apprised the defendant that there is this potential issue. Not that the attorney should have done it, but we're saying that the court had an obligation. What Rio said was the court doesn't have an obligation to make an inquiry based on the defendant's
I
statement.
don't see how we ever get any cases processed in this state if that is now a new obligation.
So I'm just curious, this was attempted rape of a 14-year-old
That is
girl. And he received 6 months on a plea and 10 years probation. What was he potentially likely to get if he, what's the exposure on attempted rape of a 14-year-old?
It's 1 1/3 to 4 is what he could have gotten as, it's an E felony that he pled to. But again, he was charged with attempted rape, so that would have been the D felony. So again, you're looking at 2 1/3 to 7 that he could have received back in 2017 when he was charged.
He got 6 months probation.
6 months
Six
and 10 years
jail,
probation.
And then
6 months here.
6 months
jail.
and 10 years probation.
Good afternoon, Emily Aldrich for the People.
Counsel, when is the court's obligation triggered
When the
for further inquiry, just so that we're clear?
when the allocution at the plea either negates an element of the crime or raises the possibility of a defense. That did not happen.
It's not just the allocution, though, as my colleague pointed to. If that pre-sentence report, if he had said, I didn't do this, my lawyer forced me to take this plea, then the judge would have had an obligation to inquire, would he not?
That certainly is not what happened here.
That's not my question. My question was, if that was in the report, the judge would have had an obligation to inquire, correct?
Yes.
So it's not just the allocution.
Correct, but
Okay.
here, both
You made a statement and it's incorrect. I want to make sure that we all recognize it's incorrect.
well, there's nothing here in either the allocution or in the PSR which would in any way go against this.
There's nothing here to inform the judge that the defendant is claiming innocence or the defendant is claiming a defense or something else, right? There was nothing brought to the attention of the judge. What your adversary is saying is that the judge should have known by reading the pre-sentence report that there were elements missing. What do you say to that?
Well, as your colleague pointed out, this is similar to instances where somebody is then contesting what happened before the grand jury. Here she testifies in the grand jury that he had groped.
Are you aware of any legal requirement, case law, statute, where the pre-sentence report has to be the equivalent of an indictment?
Absolutely
that
not.
has to have all the elements of all the crimes?
Absolutely not, no. And here he had agreed to have sex with the 14-year-old. He had paid the money. He then paid for the cab. He paid for the room. He's left alone in the room with her. He gropes the outside of her clothing. He opens up her pants. Did he actually penetrate? No. This is similar to, this is, as the Sora Court recognized, this was a legitimate attempt. This was not something that was then, pled down. But this was not something where, he had to actually be on the verge of penetration for it to count as an attempt. This was, to look at Mabobian, he certainly had passed the point where most men holding such an intention as defendant holds would think better of the conduct and desist. His acts had gone to the extent of placing it in his power to commit an offense unless interrupted. Here, her pants are open. He's holding her down. There's the knock on the door. Without that knock on the door and police behind the door, which logic dictates could have been only seconds away from penetration, he may have actually completed the act.
Thank you.
No further questions after you affirm. Thank you.
I guess 30 seconds.
Oh, you have a minute.
All right.
Come on, I'm not that bad. Give me a break.
The people have consented that he was improperly charged and he wasn't credited with the 6 months that he served. I do want to point out that by the time this court renders its decision, Mr. Ruiz will have completed 9 years of his probation without incident. He has 10 years of his life has been spent on a basis as what happened in this case. Meanwhile, the people who were the pimps in this case, the people who human trafficked a 14-year-old got 1 year and 1 to 3 years. They were so leniently treated, and my client client ended up getting 10 years of probation. That's not fair and just.
Isn't the 10 years of probation mandatory on this kind of offense?
It is, it's absolutely mandatory on this. And so, but again.
Then what are you asking?
Well, I'm just pointing out that there are inequities in this
We
case.
don't disagree.
Okay. Thank you, Your Honors. Have a great day.
Okay, we don't disagree. Rosenblum versus City of New York.
We're all appellants, yeah.
Who moved first?
I suppose I did on behalf of the...
And you go first. And just tell us who you're representing when you come up. You may proceed.
May it please the court, good afternoon. My name is Michael Andreo from Brooks and Byrne on behalf of appellant, respondent, defendant, the City of New York. There are multiple components of the lower court's decision that are being appealed from, but I'll begin with the reversal that we seek on the Labor Law 240 sub 1 cause of action.
Hold on. Gentlemen, could you take that outside, please? Go ahead.
Thank you, Your Honor. As the court is well aware, this statute only applies to situations intended to protect the plaintiffs from the dangers of a gravity or elevation-related risk.
So why are you saying this is not an elevation-related hazard? He walked on this, he said he got out of the truck. He had pretty much nowhere to walk other than right on this platform, and he fell 2.5 to 3 feet. Why is that not?
Because, well, and maybe the distinction needs to be a little clearer. This was not a platform that was covering or intended to be.
Does it matter if it's a platform and it collapses and a worker falls? That's 240.
Well, in this particular instance, I think the lower court didn't address what we view as controlling principle from the Court of Appeals in Salazar on strikingly similar facts. Concrete poured over an open excavation, similarly shallow like this one. And the Court of Appeals in Salazar said it would be impractical and illogical to require protection or covering of the opening where it would have
There was a covering. Counsel, this is a platform, and the platform failed.
The platform, Your Honor, respectfully,
The platform failed.
it was not covering the excavation. I just want to make that clear.
Does it matter?
I believe it
What
does.
he steps on gives way, and he falls.
But he falls into.
Classic 240.
But the reason.
And our case law, it doesn't require a specific height differential. Inches have been declared to be sufficient. So I don't understand.
Yeah, but he fell. The gravity impact here is not so much the platform, which is at ground level that he's walking on. It's what he fell into, right? That's the elevation-related risk, arguably. That could not have been covered or protected in this instant because it would have directly impeded the work that he was about to do.
You're missing the point. What he had to traverse had to be safe for him to do so, and it wasn't.
But even if.
Period. They provide a platform, and the platform fails. I don't understand. I really don't understand why you're not getting this. He's given only one area to walk on. He walks on that one area, and it collapses.
That's arguable.
That is precisely what 240 sub 1 is intended to protect.
I won't belabor the point because I'd like to just touch on a couple of, unless the court has other questions on 240, I'll move on briefly. The Labor Law 200 and negligence claims in this particular, we view that those should absolutely be dismissed because the city was not negligent in this case. They were the owner of this Webster Avenue bus project, subcontracted the whole kit and caboodle.
Oliveira who did
Oliveira who dug the trench, put this.
figured out where to put it, they did everything.
Right, they directed this plaintiff on site, they hired his employer. We view this as a complete pass-through. With respect to the contractual indemnity, which is part of what we feel should have been granted in this case, there's no requirement that the city be, the court seemingly read in a negligence component to that. It is not. It's your standard classic, to the extent permitted by law, arising out of the work. There's no even contention or otherwise that this didn't arise out of Oliveira's contracted for work. So we view that the negligence and 200.
So you should get indemnification and it's not conditional because you were not negligent.
Correct.
It's your position.
Correct. That's our position. And the court, I mean, as of right now, we're held liable. The city is held liable under 240. there's no finding of negligence, right? And that's exactly what this indemnity provision contemplated. If it's held liable by virtue of statute and no negligence, it passes through and it arose out of their work. Lastly, with respect to the two perhaps it's, given our discussion, it's better left for any rebuttal. But unless the court has any further questions, I'll pass it on to my colleagues.
Give you 30 seconds for rebuttal. Okay? All right. You may proceed.
Thank you, Your Honor. Good afternoon. Susan Mahan for...
You're going to have to bring that mic down and try to speak up a little
sorry.
so we can hear you, okay?
Very sorry, Your Honor.
All right.
Susan Mahan of Gartner and Bloom for the defendant, appellant, respondent, Oliveira Contracting.
Okay.
If I may, Your Honor, your position on the 240 is obviously very clear, but if I just may point out again that the plaintiff was working at street level, and what he was walking on was the rebar formwork. He wasn't, it wasn't a traditional, what you would think of as a traditional platform, or it wasn't a
Yeah, but your people directed him to drive his truck on it. So clearly, if a cement truck can drive up on it next to the place of the pour, it certainly should hold up a human being.
Well,
if it can hold up a cement truck.
Yeah, you're correct in that, but Your Honor, pardon me, but your premise is incorrect because the cement truck was on the street.
Did he fall about 3 feet? Was it about 3 feet? Even though you're saying it was on ground level, was the fall about 3 feet?
He says it's 2.5 to 3 feet. He actually says that as he stepped on the rebar, the rebar gave way. His foot went down 2.5 to 3 feet, and then he fell.
So if we're looking at that rebar as the safety device that's supposed to prevent his foot from going down 2.5 to 3 feet, it would be that safety device, the rebar, failed.
You're correct, but the rebar is not an enumerated safety device under 241.
So he shouldn't have been allowed to get on it in the first place. That doesn't help you.
No,
he was directed to this spot. He was told to park here.
Your Honor.
And he had only one plate. His door is where it is. So he's getting off the truck because he's the one who has to turn on the machine so that the pour of the concrete comes out. So you guys had to provide him a spot to pull in the truck and to exit his truck safely.
He did that, Your Honor.
And then he fell through because it gave way. Well, so it didn't support him.
Your Honor, I would submit that this is an ordinary danger that we have in construction sites all throughout the city of New York.
The floor that you're walking on just gives way. That's just ordinary happenings on a construction.
Well, it's not, you know.
That's not what should happen on a construction site, right? And if a worker has to work in a particular area, where he walks should support his weight at the very least. No?
Yes, Your Honor, and yes, that is correct.
And it didn't do that here.
It did not, according to, but again, 240 is elevation-related risks, and he's working at street level.
I want to ask you about the 200 claim. Your witness testified that the city inspectors were on site, I think daily or at least
often.
How does that weigh into who was supervising and directing the work?
Your 200 case, this would be, as Corporal held, this was going to be a notice case. It's our position that with the inspectors from the city on site daily.
You're saying that it's a notice case, meaning that there was a dangerous condition as opposed to means and methods?
The court below said it was a notice case in terms of the 200 claim, and
yeah, but a 200 claim either falls into the means and methods.
It can,
right, or
notice,
or unsafe place, unsafe workplace.
But if
right?
Yes.
And so issues of notice always come up with that. But those are the two issues in 200.
Yes, Your Honor, but if the city is on site and have inspectors on site, and this is an allegedly dangerous condition, this is a project that went on for 3 years. If the city is observing that and doesn't say to Oliveri, you want to fix that, we don't like that, that's an element, that's negligence or a potential negligence claim against the city, and that's why we believe the court below is correct in denying the city 200.
Why
judgment on
isn't this the means and methods and notice is not an issue?
It's, in terms of the city, because the city wasn't actively doing the work, but the city was there observing the work, it has to be a notice claim. It has to be a notice argument. I mean, and that's what the court below ruled, that this was a notice.
But wasn't Oliveira the company that was responsible for safety on the project? Didn't even your people say that during deposition?
Yes, Your Honor,
Desa?
but if I may, I mean, everyone's responsible for safety on a construction
No,
site.
but that was your contractual obligation, so that's different.
Yes, and if I may, just on the indemnity very briefly,
You have 9 seconds.
we think the court below was correct in denying the city's, motion to dismiss I'm going to get this reversed. We think the court below is correct in denying the city contractual indemnity. Thank you.
Thank you. Counsel?
Good afternoon, Your Honors. Daniel Lay for Plaintiff Respondent Appellant Andrew Rosenblum. I'll begin with Labor Law 240. So as Your Honors have definitely pointed out, there is definitely an elevation risk. I just want to really briefly correct one factual dispute that counsel may have mischaracterized. So plaintiff actually said he fell 2.5 feet to 3 feet lower than where he was originally standing. And this is an elevated platform. So that's why the elevation is actually 3 feet. And as this court has found.
So it wasn't street level?
No, and this is not a street level case. This is not a.
Wait, look. He drives up to the site. So when he was on street level.
Yes.
But there was an excavation.
And that's what.
And he falls into the excavation.
Exactly. And
Correct.
he fell completely.
So he falls into 2.5, at least 2.5 feet of that pit that he was going to put the concrete into, correct?
Exactly. Yes, that is
Okay.
exactly correct.
All right.
And he said he fell completely into the pit. And that's also on page 281 to 282 of his testimony. He says, I was completely on the rebar. And just to really go briefly into the court's precedent, there is no bright line minimum height differential. But a fall of 3 feet into excavation is clearly not a de minimis fall and poses elevation risk.
We've had cases with inches. be
Exactly.
sufficient. Yeah.
And we cited one as well, Telesford, that recently came out of this court, which was 8 to 12 inches. So this is not even in the gray area of elevation risk. So there clearly is an elevation risk. And turning to the safety device, the platform itself was the safety device. As this court has found in Rubio v. New York Proton Management.
That your adversaries say it wasn't a platform.
Your Honor, I think he said it was an elevated platform. He was walking on top of it, and he fell 2.5 to 3 feet. So that's what makes it an elevated platform. I don't think there is any dispute about how far he fell. So that makes the elevation risk essentially undisputed here. And, you know, it actually was the only means provided to allow plaintiff to traverse the excavation.
Was there any other place that your client could get out of the truck and do his job vis-a-vis the concrete pour?
No, exactly what you're saying, Justice Manzanet. Plaintiff was directed where to park his truck. He was forced to.
He was directed by whom?
The workers at the site, and he believed those workers.
And the workers at the site were Oliveira's people,
Exactly.
correct?
That's what he believed. He wasn't sure because he doesn't work specifically for that site, and we didn't have specific testimony on that point. I just want to briefly turn to Labor Law 200. The city, this may actually be one of the hybrid cases where it's both a dangerous condition and a means and method. But just turning to the fact that the city.
So then if we're talking about the dangerous condition, how do you have notice to the city?
Well, Your Honor, we did not move for a summary judgment. So actually, it's the city's burden first to establish that they lack notice, and that's where they failed. They only talked about supervisory control, and that is separate. That goes to means and method. That's separate from their burden in a dangerous condition case to establish that they lacked actual or constructive notice. And here, they submitted no evidence about that. Nothing about inspections, nothing about maintenance, no testimony from their inspectors who they admitted were on site in their brief multiple times. On page,
Was there any evidence, because I didn't, not thinking of this now, so I didn't check this. Was there any evidence in the record with regard to how long the condition that plaintiff drove into was in place before the truck arrived for the pour? Typically, that's set up before the concrete is ordered. So how much before the concrete was ordered to arrive to fill in this hole, was that hole and rebar in place? Do we know that?
we don't. And plaintiff, of course, didn't work for the general contractor. He worked for a separate company that delivered just the concrete. So there isn't any information about that. But to the fact that this should be a dangerous condition case, at least it was a condition that existed on the premises before plaintiff started work. So that's why, at minimum, the dangerous condition theory should stay. And the
What exactly was the dangerous condition?
The dangerous condition is the inadequate platform that was unable to hold plaintiff's weight the second he stepped up.
That's something that's observable that is, by looking at it?
It may or may not be.
Because I think the testimony was that it's pretty normal to walk on this rebar.
He said he was forced to walk.
Well, that's true. He said he was directed to where to park and to walk on the rebar. But I think there was also testimony that in terms of this type of project, that walking on rebar is accepted.
That may be true as to whether it was accepted, but there is issues about notice because plaintiff said he complained about the build quality of other platforms and perhaps this platform as well. I could just give you the record site for that.
It's okay, you're out of time. Thank you so much. Counsel, you have a minute.
Thank you, Your Honor. And just quickly, as Your Honor aptly noted, this is not a readily observable condition, if we want to call it that. And while there's no testimony as to exactly how long it took place, this project was proceeding along Webster Avenue. So it was a design build as a...
But if it was going on for 3 years and you were the owner, you had no responsibility to ever go and look at it. I'm looking at a picture from page 635 of the record. I don't know if that's the accurate picture of what this looked like at the time of plaintiff's fall. I mean, it was in the record, I didn't make it up, but it seemed like this was the picture people were referring to.
I think there were pictures showing generally the trenching on the site. I don't believe there's any testimony about the specific location of the scene at the time he fell, but there are other photos showing what, and he describes them at there's photos at 413 and 14, where the whole bus lane is filled out, and he talks about that, the wooden platform as being what he fell on. I see that I'm out of time, but we just reiterate the arguments and I'll rest on the papers. Thank you.
Thank you so
for your
much.
time.
Counsel, you have a minute? Thank you so much. Okay.
Your Honor, I believe I have 1 minute as a appellate.
Yes, you do. Sorry about that.
No problem. I just want to briefly address Labor Law 241-6. There's only one industrial code provision at issue, and the only question is whether the opening was large enough for a person to fit. Here, the Supreme Court only thought about the depth, but he didn't consider the fact that this is a width of a bus lane as well. And also, there is testimony from plaintiff that he fell completely into the excavation. So I see your honors have my arguments, so I'll rest on my brief. Thank you.
Evans versus Poulter.
Good afternoon, Your Honors.
You may proceed.
Thank you for the time. I want to focus on, because I've abbreviated my time, on one particular issue, and that is, of course, the most important issue is that whether these comments were in fact defamatory under New York law. And as I said in my brief, what's important and really essential is to look at the entire context of how these statements were made and how they were published to other people. Not the individual words, because individual words in and of themselves can be and cannot be. But unless you look at how these words were directed and how the punters directed them repeatedly. And first what they do is they contact Commissioner Castro, who was my client's direct supervisor. But not happy with what happened there, they then organize and have a secret meeting, which my client never was advised about. Neither was his attorney at the time, because he was represented by an attorney from DC 37 at that time, about this meeting. But this meeting isn't only supervisors from the Parks Department. There are representatives from the State Assembly, representatives from the State Senate, people from the Mayor's office, people from
Counsel,
the AG's office.
If we were to find that these were non-actionable opinions, do we even get to the position that you're arguing here?
I don't think, with all due respect, that you can reach that decision without looking at what happened, how these were published. Because publication's obviously a key part of defamation. If they just mailed the letter to my client, there's no defamation. But once they decided to not only make the complaint to Commissioner Castro, but also then republish it to this committee. And I put in my brief the notes from the Parks Department, they keep reporting notes, and they repeated how they were comments about, well, he has to be, it's in my brief, but it says, after this meeting, comments from the Parks Department senior officers included, quote, our apologies for alleged poor behavior from park staff. This is an apology without my client being present at this Star Chamber meeting. And then they say the completely unprofessional.
Say that as though there's something wrong with the Parks Department meeting with members of the public. There's nothing wrong with that.
No, there's nothing wrong with that.
So I'm not sure what that argument is getting to, because they are completely entitled to have a meeting with whomever they like.
That's absolutely correct.
So let's go to the actual words that were said, and
That's
you
fine.
explain to me
fine.
how those words, which seem to me, speaking only for myself, to be opinion.
Well, those words, first of all, those words, as I laid out in my reply brief, were clearly found to be actionable words as a basis for a disciplinary proceeding. And page,
That doesn't, look, the fact that someone gets disciplined based on an opinion doesn't change it from being an opinion.
it doesn't necessarily,
Okay,
but
so again, tell me how it meets the standard of defamation or libel, because we have to start there. I don't get to the context until you explain to me how the words satisfy the definition of defamation.
I believe those.
So let's start there.
I believe that those words do satisfy that element, because a fact finder, which was the case in the disciplinary proceeding, a fact finder found that those words were improper and inappropriate. And that's a higher standard, that's a substantial evidence, which is a higher quantum of proof than a preponderance of the evidence. If there was a substantial evidence agency proceedings is always the standard of proof. My client's looking for the opportunity to present those words to a 6 or 12 person veneerman who can then make a determination, yes, your words were in fact actionable, were the claims by the respondents, by the defendants, were in fact actionable.
Also, we make those determinations as a legal determination
I understand
first.
that.
So explain to me how you get past that very first bar. Because again, I say to you, the words of some of in the letters refer to him as aggressive, unprofessional behavior, pointing his finger at an 80-year-old man while speaking and standing over him, etc. Okay? That all is opinion.
With all due respect, Your Honor, I think that within the context of how these words were published to other individuals and the actions taken by the Parks Department against my client, and where he basically was never promoted even though he applied
So
repeatedly.
counsel, if the Parks Department had not disciplined your client, then Had the Parks Department not disciplined your client, then the words would have been opinions?
I think that that would be a less of proof that it was, that it was defamatory, but I don't think it would be actually determinative in and of itself.
Thank you.
Thank you, Judge.
Okay, good afternoon, Your Honors. Jerry DeCamp for the respondents, Malcolm Punter and Harlem Congregations for the Community Improvement. As Your Honors was saying, the words or the characterization that Mr. Punter used to describe Mr. Evans' behavior that day as such as aggressive and inappropriate or non-professional, they are opinion. It's not actionable. It's not a defamatory statement.
How about if we look at it in the context that there was communication, I'm not sure if it came from your particular client, that said that they want him to be reprimanded, right? I mean, that's clearly directed to do some kind of, well, not clearly, I'm not going to say that. That might be interpreted to be for the purpose of reputation harm or something like that. Do we look at everything in the context, or are we taking it one piecemeal?
I think you look at it in the context together, but again, that's also somebody's opinion that they think maybe someone should be reprimanded, which I don't believe was in Mr. Punter's letter. But the fact that it's two is whether or not something is defamatory, there also has to be a damages component. And in here, I know counsel was raising that he
Let me see,
hasn't.
organizing a meeting with every potential heavy hitter in the region to attack this man for doing his job when the organizers of the event clearly violated the park rules. Come on, let's call it what it is, okay? You ask for one permit and you do something else. He's doing his job, and maybe he did it not so well, maybe a little too zealous, okay? But he was doing his job. And the people who were organizing the event weren't doing it properly. So there's fault on both sides of the fence, but he's the only one paying the price for it. So let's not pretend like that's not what happened here.
I would disagree with you saying that.
I'm sure you do.
Well, you're saying that they didn't.
But we had an assemblyman, we had a bunch of heavy hitters have a meeting without the benefit of him or his representatives. That's not fair either, is it?
Well, there was a community meeting held, but it wasn't.
But isn't he a part of the community? Why was he excluded? It was about him.
It was not our clients that organized this meeting. One person that the testimony of Mrs. Punter was that they received a call from Robert McCullough, who was the elderly gentleman that was kind of the target of Mr. Evans' aggressive behavior, and he contacted them and said, "Look, we're going to get a full meeting."
Then Mr. Rivera became the target of Mr. McCullough.
No, it wasn't the target. It was raised because, and the individuals that there have a qualified interest, or they have a common interest, and it was a qualified privilege to advise these people.
And so does Mr. Rivera, to make sure that the park is used properly and that proper permits are obtained for events. There's no question that the permit that was received for the event in question was not the right one.
Your Honor,
there's no question about it.
The issue here is whether or not the statements made were defamatory. And the
don't look at us. Let's just look at him. I get it. But the point is that had your people done the right thing, we wouldn't be here because he wouldn't have had to go and enforce.
That's not true, because if that were the case.
Put your finger down. Don't you put your finger up at this
point.
You just went like that. Don't do that. Don't do that.
I wasn't trying to be disrespectful. I was going to say that in the interest of...
Go ahead. In the interest of?
The whole point of the meeting was to speak with the community representatives about what would happen as a means of conciliation and to move forward from it. Mr. Evans was not demoted. He was not fired. He raises that he has not been promoted. He hadn't been promoted in 14 years before this incident. He received raises year after year following this incident. there was no disciplinary proceeding with respect to that, or he was not held back in his career advancement. He hadn't advanced for 14 years before that. Unless your honors have any further questions, we'll rest on our brief. Thank you.
Thank you. You may proceed.
Good afternoon, Your Honors. May it please the court, Matthew Lavoie for respondents Arian Punter and Rucker Park.
Arian Punter was the individual who sent the email wanting Mr. Evans to be reprimanded. Is that correct?
Yes, Your Honor. So Mrs. Punter said she requested that Mr. Evans apologize to Mr. McCulloch and that he be reprimanded and retrained to communicate with the public.
So yes, reprimanded?
Yes.
Okay.
She used the word reprimanded, of course.
So why isn't this an actionable mixed opinion?
So, Your Honor, so the statements of Ms. Punter describing appellant's behavior as offensive, contemptuous, bad-mannered, aggressive, and the like, those are clearly subjective opinions. What one person may consider aggressive, another person may consider not to be aggressive. This is demonstrated by the fact that actually appellant's counsel had to ask Mr. Punter what he meant by the word aggressive when he used it during his deposition. It's obviously a subjective word, as many of these statements were. You're talking about a combined,
Right.
could you repeat your question? I'm
Actionable
sorry.
mixed opinion.
So she asked that he be reprimanded. That's an action.
Oh, I understand. Okay, yeah. I think the issue there is that in order to have a case for defamation here, you need to prove there's an injury, even if Let me start over. So intent is not really relevant here. Whether Ms. Punter wanted him to be disciplined or reprimanded or undergo training, that has nothing to do with whether her words were opinions. Furthermore,
but why can't we say, well, the fact that he's raising this issue that he hasn't been promoted for, I think it was 2 positions or been considered for those 2 positions after this, why isn't that some indication or maybe at least a question that should go to the jury as to the context of everything that's been happening?
yes, Your Honor. So there we have an issue with causation. There is no evidence that appellant was held back for anything because of the statements. There's nothing substantiating that at all. In fact, all of the testimony from appellant's own boss, who was in charge of filling this this position that Mr. Evans subsequently applied for, he testified that he reviewed the applications and he was asked, was Mr. Evans qualified for this position? He said, I didn't think he was ready for that position. I didn't see him as a good fit. He said, I didn't see him doing what needed to be done there based upon my fairly long experience with him. And then he was asked directly if he felt that he wasn't a fit for the position because of this event. And he said unequivocally, no, not at all. He said, whatever happened, I wasn't there, but no, that didn't affect me. So this is clear evidence here from the testimony of appellant's boss. He was in charge of whether he got this position. He thought that he was not the right person, was not suited for the position, had nothing to do with this event at all, or the statements made by my client. The appellant talks a lot about this meeting, but really, again, this meeting has nothing to do with the statements that my client or the other respondents made. This was, as counsel said, this was a qualified privilege sort of thing where they had an interest in making sure that this was a community issue. They just wanted to make sure that the Parks Department employees were acting professionally in the community. That's really all it was. There was no...
Why no community interest in making sure that the proper permits are given to organizations that are having events in the parks? Where was the interest there?
I don't dispute that my client didn't get the permit. My client was just there. I don't dispute that Mr. McCulloch got the wrong permit, but that's not really relevant for this defamation case. I agree he should have got the right permit, but I mean, no one sued him for getting the wrong permit, so it's not really relevant here today. Unless Your Honors have any further questions, I'll rest on my brief. Thank you.
I'll just address a couple of points, Your Honors. Okay, first of all, as to who called this meeting, when Malcolm Punter was deposed, He specifically testified as follows: "I was asking for a meeting to discuss this matter with the hopes of meeting with individual staff as well as their survivors," and that's on page 355 of the record. Who called this meeting, obviously, is a fact that needs to be determined, and whether was it Punter or was it someone from the Parks Department? And this goes to my argument that these are issues that really cannot be settled in a motion for summary judgment where a jury can make this determination. As to whether he was qualified or not for a position, Commissioner Castro said he wasn't a good fit for a particular position. And there is a big difference between someone not being qualified and not being a good fit. I am clearly not qualified to apply for a job as chief of surgery at Mount Sinai. But if I apply for a job at, let's say, the U.S. Attorney's Office in charge of their appeals bureau, they could say, well, he's qualified because he's been practicing law for decades, but he's really not a good fit. So there is a distinction here that has to be made. So, okay, and I think the record is pretty clear, and I would respectfully request that you vacate Judge Cohn, who's a really good judge, his decision, and let a jury decide my client's fate. And I thank you for your time, Your Honors.
Priestley versus Nycha.
Thank you.
Proceed.
Thank you, all your honors, for finally, this is the first time that I've had any kind of, hearing.
Okay.
As to since 2008, I've had all these issues with the housing authority, constantly harassing me, constantly, agitators of the housing authority, constantly agitating me and making my life miserable. And I've never had, constantly through multiple proceedings errors, I've never had a chance to be heard up until now with you guys here.
Okay.
But the whole thing is, the substantive admission of my request to admit, that they said, my admission number 4, that I have never had any kind of hearings on all my cases against the housing authority on the merits. I've never had them up until now, really.
Okay. Tell us what you want.
That totally invalidates the pre-filing injunction. That they rely upon this absolutely ludicrous pre-filing injunction from this judge, who right when I'm getting a CCRB report where I got 2 cops, up on substantiated charges, she goes and it dismisses my complaint and then says that from all the times up until April 7th, 2022, she made her dismissal of my complaint. And the CCRB report, this esteemed institution ruled in my favor and got these 2 cops, up on substantiated charges. And that came out on March 25th, 2022. And she makes her dismissal on April 7th, 2022 for all claims that might have happened before April 7th, 2022. Are they going to rely upon that? It was an obvious mode of proceedings error in Reed Murchison, in Reed People versus Patterson, matter of Esworthy. It was an obvious mode of proceedings error.
All right, you'll have time on rebuttal.
Good afternoon. May it please the court. Patrick Lawless for New York City Housing Authority. Justice Lattin properly dismissed this complaint as precluded by Justice Jaffe's prior order. The complaint itself alleges a longstanding surveillance and harassment. There's no new issues. And unfortunately, the plaintiff took an appeal from Justice Jaffe's order. That appeal was dismissed as abandoned. So the issue of the correctness of Justice Jaffe's order cannot be reviewed on this appeal. And there's no basis for overturning Justice Lattin's order. Unless there's any further questions, I'll just rely on my brief.
Thank you.
Thank you.
Sir, you have some time on rebuttal.
But no, that's absolutely ludicrous. We are not here to do about the appeal for 159-234 Justice Jaffe's order. The whole thing is Mr. Lattin, Judge Lattin, he referred to the the injunction as the reason for his dismissal of the case below. You know, he's trying to make it out. Like we're here like to relitigate 159-234-2021. We're not here for that. Like we're here to relitigate 153346. And Justice Ladden said that the reason why he dismissed it was because of the pre-filing injunction of Justice Jaffe. And the pre-filing injunction of Justice Jaffe was absolutely ludicrous. And she did not give me a chance to have any kind of section NYCRR 130.1.1 D hearing. She didn't give me any kind of anything for that. And then plus that, most of the incidents that happened in my 153346, most of the incidents that happened there happened after she made her alleged injunction, which was still, you know, a bull crap. But she made that for all instances after April 7th, 2022. But most of the instances of 153446, which we are here in court for today, happened after April 7th, 2022. And then it's not for nothing. I have a request to admit that they admit that I'm a fraudulently targeted Pfizer victim. They admit it. They admit that there are covert audio-video devices inside of my apartment. They admit that I'm part of a stalking program. They admit that they have illegal constructions around my apartment to spy upon me 24/7. I mean, I think that there's a big public policy, you know, thing here, like as to Pfizer, because you know Pfizer is up for repeal, you know, soon. And I believe I could have a lot of public policy issues as to the repeal of Pfizer, or at least the reform of the Pfizer program. I'm sure most of you guys hate Pfizer.
Thank you so much, Mr. Priestley. We will take your case under advisement. Thank you.
Thank you.
People versus Marcus Turner. You may proceed.
Good afternoon. My name is John Palmer, appearing on behalf of Marcus Tyler Turner.
Counsel, if we start from the position that the appeal waiver is valid, what are we to do about youthful offender? Are we precluded from reaching that issue?
Well, you would not be precluded from reaching it in this case because there was an erroneous youthful offender determination, and in fact, or in the event that the court failed.
What do you mean by that? That there was an erroneous determination? Is it that the court failed to consider youthful offender, that the court considered improper facts in determining youthful offender, or that the court just got it wrong and should have granted youthful offender?
So here, Your Honor, with
All of the above.
Oh. In fact, I'd say all the above. But in response to your question, the court's reliance repeatedly on the youthful offender eligibility factors, even though Mr. Turner is obviously eligible for youthful offender determination, is tantamount to a failure to consider youthful offender status for Mr. Turner.
So if we agree with you, right, that the court got that wrong, what's the remedy?
Well, we would ask for this court to afford Mr. Turner youthful offender treatment.
Is that for us to do, or should that be on remand?
I mean, do we have the power to do that based on the posture of the case as it is?
Well, Your Honor, yes, this panel does have the power to find Mr. Turner a youthful offender.
We know we have the power to send it back for the court to consider it again.
And that's why I started from the position of the valid waiver. How does that play into what we do moving forward? Are there limitations?
Well, if you find the appeal waiver valid, which of course we would argue that the court should not find the appeal waiver valid.
But if
because
we
it was,
do, what is the impact of that? If we think the waiver is okay, can we even consider the youthful offender? And if we do, is our limitation just to remand it again?
if you find that the lower court failed to consider youthful offender status, For Mr. Turner, I would argue that this panel, can afford
Is
Mr.
that your position, that they failed to consider youthful offender? Is that what you think happened on this prior remand?
Right, that is what I believe happened here in this instance, is the court failed to consider Mr. Turner for youthful
That's
offender
happened
status
twice,
repeatedly.
right? Now, in this case, right?
Exactly,
Same court?
same court.
Because the second time around, it appeared that the court was confused about the facts of the case.
Correct. The court initially started talking about a sex offense, I believe, and then started talking as if there were multiple instances when it's uncontroverted that we're talking about 2 charges arising from one instance, a possession and assault offense. And there's no indication that they are separate, offenses.
And on the first go-around, the court mistakenly believed that mitigation was required when it wasn't.
Exactly,
Correct?
thinking that Mr. Turner was presumptively ineligible because of the offenses, but of course we know that he is eligible and deserving of youthful offender treatment. So we would ask the court to afford Mr. Turner youthful offender treatment as he is deserving of it. As 18 years old, he exchanged gunfire with these local gang members, believing his life was in danger. And because the mitigating circumstances of his background and the offense itself and his growth since that offense demonstrated at the resentencing, would ask the court to afford Mr. Turner youthful offender treatment, or if the court feels that the lower court failed to consider him yet again, to remand.
Thank you.
Good morning, ADA Mallory Phelps for the people. Defendant's waiver of his right to appeal was knowing, intelligent, and voluntary, and therefore it should disclose successive sentence and youthful offender claims. The court below properly explained the right to appeal and the waiver.
Let's assume, go ahead. Well, let's assume that we agree with you that the waiver.
Ask the same question. You keep going.
No, go ahead.
Lost the question. Assuming that we do agree with you, and we're going to start from the same position that we put to your adversary, assuming that the waiver is valid, how does the record show that the court properly considered the youthful offender status?
Of course. Well, the court, the first time around, did not properly consider youthful offender status because it was confused and assumed that because he had been charged with something that would make him ineligible, presumptively ineligible for youth offender status, that even though he pled guilty to a lesser crime, that he would still need to show these mitigating factors. And so it was sent back to the court, but then the court was corrected by this court from misunderstanding, no longer believed that that was required, and talked about the facts of this case. Specifically, the court explained the reason youthful offender status.
Completely confused about the facts of this case.
The court
completely. I mean, counsel had to tell the judge, that's not this case.
Correct the court. The counsel did have to correct the court about what case he was talking to, but then the court, when it made its decision, was talking about the facts of the case. Specifically, they said the reason the court didn't want to grant youthful offender status was because of the seriousness of the crime, as this was a shooting in broad daylight on a public street, hit an innocent bystander, and because the defendant had initiated the shooting. The defense has tried to claim that this is a shooting in self-defense. We have surveillance footage which shows that he was the instigator of the shooting.
No. You have surveillance that happens to show him shooting a shot. It doesn't tell me what happened before. So it doesn't prove that. I'm sorry. It doesn't prove that. I know you'd like to say that it does, but it doesn't. That is your take. And I accept that that's what the people think is what happened. That's not borne out by the evidence. We don't know one way or the other.
Well, the surveillance footage does show the incident, and it is true that
shows the incident on the street?
Yes.
Right. And it started inside the store, right?
I do not believe so, Your Honor. I believe that he was walking down the street. On the street corner, there were rival gang members. He shoots at them. They shoot at him back after he fired shots.
Okay. All right.
Counsel, but one thing, in terms of whether this young man is deserving of YO, I did note that the prosecutor did something in this case that it rarely does. On first remand, you agreed to lower the sentence.
That is correct.
True?
That is correct, Your Honor. We lowered it from 3 years in prison to 2.5 years in prison. And that's due to the mitigating factors that defense is arguing now on appeal.
It does seem that YO was created for this young man. right? It seems like the textbook case to grant YO adjudication. You don't have to answer that.
And I would just add that in reviewing the transcripts and talking about the detail that this judge put on the record, I think we're being a little bit generous in saying that there was detail. She merely says that the manner in which the incident took place and the direct role the defendant had. I mean, is that enough? Should there be more when we're considering something as important as this youthful offender status that would affect the rest of this young man's future?
Of course, a more detailed record would always be preferred, but the judge did give,
Especially since we sent it back.
correct, Your Honor, but the judge did give two good reasons: the seriousness of the crime, and this is very serious. An innocent bystander was shot, and it was.
I mean, to do very general reasons, that could apply to anything.
And he wasn't, the shot grazed the victim, not to minimize that. I don't want to be grazed by a bullet, but it wasn't like they were shot, right?
Correct, Your Honor, he was grazed.
Kind of, we've seen that before on TV.
Of course, he was grazed, and of course, that's better than being killed or seriously injured, but shooting on a public street in broad daylight when there are innocent people around creates a risk that's very serious, especially when he was attempting to shoot.
I mean, you're giving more detail than the judge did.
Yep.
Is that acceptable when we're reviewing the record and there's certain requirements when we're considering something as serious as youthful offender status, whether or not it's going to be given or not, and when the case law says you have to put these things on the record, is that sufficient? You just gave more detail than she did.
I think it is sufficient, especially with the knowledge that the judge was the judge on this case, so has more background
No,
knowledge.
the judge in this case, if you go back a couple more pages on it, she says, I'm confused. I don't even know what's going on. And then there's a conversation at the bench after the defense lawyer tried to clarify it for her.
The judge did have to be reminded about the specific case, but once she was reminded of the case, she did talk about the facts of the case when dividing youthful offender.
Counsel, I mean, think about what you're saying. This court sends it back because there was no determination. And the judge has to be spoon-fed the facts while on the record, for God's sake?
Of course, I agree that this is obviously not the perfect scenario, and we would prefer a more detailed record, but I do think this is enough for a non-abusive discretion to deny youthful offender.
Okay.
Turning to the excessive sentence point.
We are out of time.
Thank you.
And I don't think we need to do that, seeing as you lowered the sentence, right? Okay.
I just have a couple of quick points, Your Honors. So, as Your Honor recognized, the court did not speak to the facts of the underlying incident here in denying Mr. Turner youthful offender. The court simply tracked the language of the eligibility statute, just as it did the first time, erroneously. And as far as remedy, again, I would urge the court to afford Mr. Turner youthful offender status. As you know, as this court recognizes, this is a textbook example of.
Is there any case where the waiver was upheld and the youthful offender status was granted?
By this court, right?
Yeah.
That, Your Honor, I am not certain of. But if the court feels that
If you had found that case, it would have been in your brief, but thank you.
But if the court feels that it cannot reach the youthful offender determination itself and grant him a youthful offender, we would ask the court for a second remand.
A third remand. A second remand, yeah.
Second remand before a new court, a different judge that will consider youthful offender determination appropriately. Thank you, Your Honor.
That's a tough ask.
Yeah.
Because you're asking us to undercut the judge below for no reason other than she hasn't given you what you wanted. And that is not a proper basis to remove a judge from a case. That is not.
Not because the judge did not give us what we wanted. It's because the court did not follow the court's instructions and
You
considered.
think she didn't, in the first instance, even consider what we told her to consider in our last appeal? Is that
Correct,
what you're
Your Honor.
saying?
She failed to consider Mr. Turner a youthful offender. I'm sorry if I misspoke.
Thank you.
Thank you, Your Honors.
People versus Nelson Gagum. And forgive me if I've said the last name wrong. You may proceed.
May it please the court, Mimi Lee for the appellant Nelson Gagum. Your Honor, I did say it correctly. This court should reduce Mr. Gagum's sentence from 6 years to the statutory minimum of 5 years. Mr. Gagum is turning 70 later this month, and he has deteriorating chronic health conditions. He suffered 2 heart attacks during the pendency of this case while he was incarcerated at Rikers, in which he has to take ongoing heart medication as a result. He also has a herniated disc in his back and requires a back brace. And
He could have killed his partner.
yes, Your Honor,
Hatcheted her.
the
Okay? Hatcheted her.
absolutely, the facts of the offense.
Fractured skull, lacerations throughout her body. It is amazing that the woman is still alive. And all because she would not give him her Social Security check.
And she was disabled to even start out with, so it's just a very difficult situation to read.
Yeah, the facts are awful here. The offense was very violent. We are not, asking the court to ignore that at all. Mr. Gagum did accept responsibility by pleading guilty for his actions, and he has been serving out his prison sentence currently. We are asking the court to consider that 5 years is sufficient, even in light of the gravity of the offense. Because of his deteriorating health conditions, he has it's been widely accepted that medical treatment as well as substance abuse treatment is better served in the community. Prisons are ill-suited for
I agree with you. But that's not a basis to let somebody out who uses a hatchet
yes, Your Honor.
to deal with his displeasure with an ask. This
Courts have validated that, serious health concerns are valid mitigating circumstances.
Didn't the sentencing judge consider the defendant's age, his health, his other concerns, his other related substance abuse issues when taking this very favorable plea?
Yeah, so the pre-sentence report does detail Mr. Gagum's health conditions, but the sentencing minutes do not reflect any consideration by the trial court. The trial court went by the bargain for plea.
The maximum for the charge was 15 years, and he got 6 years, which is just 1 year above the minimum.
Yes, Your Honor.
When some consideration was given.
That was a result of the bargain with the prosecutor. I believe that there were some issues with proving their case. And, the fact that it was bargained for.
Because his partner, notwithstanding him hatcheting her, was giving him every excuse under the world why he did it. So I understand why the people decided to take a plea.
Yes, and the fact that it's a bargain for plea, the Court of Appeals has stated in numerous recent decisions that that does not, take away from this court's power to reduce somebody's sentence.
Of course not. The question is whether we should. That's the issue, right?
Yes, Your Honor. And I would submit that in light of his serious health conditions, that is validating mitigating circumstances, and we are only asking for 1 year off of his sentence. I do see my time is about to be up. If I can turn to the appeal waiver or...
Your time.
The appeal waiver is invalid here. There are multiple errors that had occurred, but the biggest one being that the court required the appeal waiver rather than the prosecutor. And in the language that the court used to explain the appeal waiver, it implied that the appeal waiver would be mandated because he was taking a plea to a lesser included count. In essence, implying that any plea to a lesser included count would be subject to an appeal waiver. The trial court absolutely did not explain that it was a right he was being asked to give up in exchange for the plea. And the people do indicate on the record that they were not requiring an appeal waiver in this case. So in light of the errors with the appeal waiver, this court should still reach the merits of Mr. Gagum's excessive sentence claim and reduce his sentence by a year in the interest of justice.
Good afternoon, Your Honors. ADA Ethan Solomon for the people.
Counsel, since the prosecution did not make the waiver right to appeal part of the plea bargain, correct?
The prosecution did not require the waiver initially as part of the bargain.
So when the judge interjects and now is requiring the waiver, doesn't that imply, if not directly tell the defendant that this is mandatory?
Well, Your Honor, the judge, the plea court, there's nothing wrong with the plea court requiring a waiver as part of its acceptance of the plea.
It's your plea.
Yes, but the court still has to approve it. The court still has the power to say if the prosecution offers a deal that the court is dissatisfied with or thinks is
No, I could understand if the judge is not happy with the disposition, right? Like maybe you need psychiatric help, or maybe you need drug intervention, but a waiver of right to appeal?
Your Honor, I believe that the court can require a waiver as part of its acceptance.
Okay, so
of
if
the
it can,
bargain.
how did it explain to the defendant that you don't have to accept this?
So the court said, I believe, Your Honor, that because the people were offering such a benefit, were offering such a beneficial plea bargain, that it was going to require the waiver as part of that bargain. It did not imply that a waiver is a mandatory part of any plea bargain or that a waiver is required in all circumstances, but that in this case, because of the highly beneficial nature of the bargain, that the court was going to require a waiver. And defendant did receive an extremely lenient plea bargain in this case, from attempted murder in the second degree down to attempted assault in the first, just 1 year over the minimum for an extremely violent crime that, as Your Honor pointed out, could very well have killed the victim in this case. The mitigating circumstances that defendant raises on appeal were known to the sentencing court, and defendant has not provided any strong reason why this court should grant him further leniency than he already received.
So you would argue then that even if the waiver was invalid because the judge failed to explain that the waiver was his condition, not the people's condition, that notwithstanding an invalid waiver, that the sentence should not be disturbed because it's not excessive?
Correct, Your Honor. Okay. And if there are no further questions, we'll rest on our brief. Thank you.
You have 1 minute.
Just a quick point on the waiver. Regardless of who is asking for Mr. Gagum to waive his rights to appeal, he needs to understand that it is a right that he has regardless of pleading guilty, and that he is being asked specifically to relinquish that right in exchange for the plea. That wasn't given here amongst all the other errors that are in the brief.
Precisely, that's why I said what I said. So,
yes,
the question is, even if the waiver is invalid for the reasons that you said, why should this court change the sentence anyway? Because even if I agree with you, invalid waiver, the court can still consider the sentence to be more than fair and adequate and not disturb it because I don't find it to be excessive. Why am I wrong about that if I thought that?
Yeah, we are arguing that 5 years is sufficient given his serious health conditions. And also, while this...
But it's not a question of sufficient, right? The statute says I can reduce it if it's excessive. Why is 6 years excessive for hatcheting somebody?
So going back to the serious facts of the case, while this offense was very violent, it is an anomalous behavior in regards to his entire criminal history. He does have an extensive criminal record, but the vast majority of his prior convictions have been drug-related. They have been misdemeanors. He does have an attempted burglary from over 30 years ago. And while that offense is legally violent, there's no indication that there was any actual violence. So the fact that this is largely in part the only violent offense that he's had, he was under the use of PCP at the time, and given his very severe health conditions, we would ask this court to consider reducing his sentence by 1 year in the interest of justice.
Thank you so much.
Thank you.
Rubin versus EFP Rottenberg LLP. may proceed.
Good afternoon. Michael Case with Barclay Damon, representing the appellant respondent EFPR group. Where a party not in privity with an accountant alleges accounting malpractice, the applicable standard is, and that's the case here, the applicable standard is the Credit Alliance case from the Court of Appeals. Under Credit Alliance, in order for a party who is not in privity with an accountant to impose liability, it must be alleged and proved that the accountants were aware of a particular purpose for which the accountant's reports were to be employed, that the plaintiff has to establish
How
that.
was that met here? What is the proof that the defendants knew that the 2011 audit was prepared for the purpose of plaintiff deciding whether to loan the company $300,000 or not?
Well, Your Honor, on behalf of EFPR, the accountant, we're contending that that provision was not complied with.
Right.
Excuse me, that condition is not satisfied.
Right, so you say
Yeah.
it wasn't met. There's nothing in the record that establishes that.
Yeah,
correct?
right. Yes, so the accounting restatement occurred after the investment that was made by the plaintiff here, so there could be no reasonable reliance upon that.
So now there were apparently, according to the plaintiff, conversations that he had with people at your accounting firm, but there was nothing in writing, and what happened was not enough. That's your position?
In a nutshell, but if I may elaborate a little bit.
Sure.
Yeah. So the purpose of the engagement by the accounting firm was engaged by continuity, not by the plaintiff. The purpose of the engagement was to audit continuity's books and prepare an audit report. That was it. The engagement letter was quite clear, saying that the audit report is not supposed to go to anybody other than continuity. It's specifically not to go to for example, potential investors of securities, or
Which was what Mr. Rubin was, a
Well, actually,
potential
not even-
investor,
not even-
right?
Yeah, he was an investor, though, correct. So there's and as it relates to this first prong, which is what we're discussing right now, there's no evidence then that EFPR, the accounting firm, was aware of Rubin, the investor's purported attention as relates to the audit report. There's no way that they could know that. There's no evidence that the EFPR was engaged to communicate with anybody from associated with plaintiff regarding the financial condition of continuity. And in fact, the audit engagement letter confirms this. You know, it says that the quote, the financial statements and EFPR's audit report.
You're talking about the 2012 engagement letter?
That's correct. Well, actually, the engagement letter pre-existed 2012. The original engagement letter, the letter by which
For the 2011 audit you're talking about?
the 2012. Yeah. Sorry.
We got to get the dates right
Okay.
because that's relevant.
The dates are crucial. That's correct. In this case, let's go. Let me back up. Okay, so the second prong, if I may move on, of the Credit Alliance test is that there has to be proof of intent on the part of the accountant that a known party would rely on the reports. And here again, I think we don't have that.
But again, it goes back to my question before. Didn't Mr. Rubin or someone on his behalf reach out to somebody at the accounting firm to discuss certain things?
We can jump into that. In short, there are a number of alleged representations upon which Mr. Rubin claims to have reasonably relied. We'll start at the top with the September 28 audit report. That's the report that contained this misstatement. It was subsequently, that was 2012, September 28, 2012.
But that wasn't the problem that
that was
the
for the-
investment was before that, was
Exactly.
in August.
That's correct. The
So we
investment
couldn't
was
rely
before
on
that.
the.
We couldn't have relied on that one. So
What
that
about the draft report?
Right, okay, great. The draft report there's a 2012 draft report. First of all, the concept, there is no 2012 draft audit report in the record. We don't know what that purported report says. We have a characterization of it orally from the plaintiff, but that's it. So we can't confirm, for example, what actual statements, representations were made, or whether they were misstatements at all. And of course, there's been no determination that it contained any misrepresentations, so it can't be actionable.
Am I correct? Because I'm just a little confused now. It was my understanding that there was an actual audit in 2011, and then there were reviews, not full audits, but reviews in 2012. Two of them at two separate points. Am
That's
I
correct. There were quarterly reviews, and there were 10 Q reports that came out of those quarterly reviews.
Right. But those reviews are not audits.
That's correct. There are expressly not audited statements. And in fact, and this is the Rich versus Touche-Ross case.
Okay.
From the Southern District, which cited in our brief. But there, as a matter of law, there can be no reliance on an unaudited statement.
All right.
You know, whether they're audited or not
Time
is.
is up. You'll have time on rebuttal.
Okay.
Good afternoon. My name is Edward Kramer. Pleased to be here. And to address the first point about privity and reliance, the case law is pretty clear. There needs to be some kind of a writing, such as an audit, a review, or anything else. And in this case, we have an audit.
There's a difference between an audit and a review, a big difference.
Yes, a review, yes, even as stated by Mr. Zimmerman at his deposition. A review does not independently verify the underlying facts. However, if there are discrepancies or large increases in receivables, they're compelled to go back and look. Also, the review here is based upon an audit where the original fraud was, and this built upon it. So this compounded.
Nice try. No cigar. But go ahead. Nice try, but no cigar, my friend.
2011. The audit in 2011 showed $500,000 in receivables.
You want to conflate the 2011 audit with the 2012 review and say that they're one and the same? They are not.
It's based on it. It confirms it.
They are not the same.
I'm not saying they're the same.
Okay, and you cannot impose the same imprimatur on the review that you can on the audit.
I wouldn't say
Okay.
that. But it's still something that can be relied upon, something that passes muster from the accountants. Now, part of that review, and the reviews are based upon the prior audit. That's the starting point, and that's acknowledged, so it goes forward. So the other aspect is that there needs to be some other confirmation that it's being used for the purpose of the person who's suing. Here we have.
How is that established here? How is that prong of credit alliance established?
Here we have Mr. Rubin's deposition testimony and affidavits, uncontested, stating that he met with Mr. Bettino, Ms. Walsh, twice a month for several months, talking about his investment. They said, go ahead, it looks good, and talking about the company.
But doesn't the case law require something in writing, a written misstatement, not just an oral discussion?
It requires a financial report.
Both. Here, to show privity, obviously we have an audit which is in writing. Then there has to be some other special relationship to be shown, and that's the oral conversations, and that's what the case law and this court has supported in the past. Now,
You're saying that the oral conversations created the special relationship, the privity?
yes,
And what case are you relying on for that proposition?
I'm relying upon Credit Alliance.
Really? Credit alliance for that proposition?
Yes, in fact, the companion case to Credit Alliance, which was the EAB case, which was part of it, there was both oral and writing for privity. And then this court in the Cherry case said oral oral conversation, communications are sufficient to establish that. You need a writing to establish that. In the council's brief, instead they talk about Lambert as saying that everything must be in writing. But in Lambert, there was never a writing. There was never an audit, a report. It was all oral. And Cherry and Credit Alliance all confirm that you can have oral, you can look at oral conversations. Now, the other aspect I'd like to address is that there has been basically no opposition submitted to the factual statements in this motion for summary judgment. And I've always learned that you need to oppose a motion for summary judgment with an affidavit of someone with knowledge of the facts. That is not here. Everything here is uncontested. In fact, Mr. Zimmerman, at his deposition, and I go on too much in my briefs about that, states that he has no knowledge of this. He wasn't there at the time. He wasn't familiar with the audit work that was done. He doesn't know if anybody was speaking to him, although it is in the interrogatories, interrogatory number 5, it was admitted that Mr. Patino had conversations with Mr. Rubin. Accordingly, to me, this case gets fairly simplified in that there
Light is red, so I need you to wrap up this
in that there
argument.
is no substantive opposition to this application. Thank you.
Thank you. You have 1 minute.
Yes, I'll be very brief. 3 points. On Cherry, the Cherry versus Herbert case, that case basically is distinguishable. In that instance, there was a transaction which had to be facilitated by the accountant's report. And one of the plaintiff in that instance then was allowed to rely upon a misrepresentation by the accountant in order to proceed with the class action. Excuse me, the malpractice action. This is quite a different case here. There's no suggestion that the report of EFPR was in any way material to or conditioned upon or relevant to, frankly, the investment that was made by the plaintiff. With respect to the oral representations that have been discussed here, the oral assurances by Mr. Bottini, one of the accountants who is now deceased, the Lampert case, there were alleged verbal assurances by an accounting firm were held not to be sufficient to support an accounting malpractice claim in view of the fact that the plaintiffs never saw any formal reports containing misrepresentations, and that's precisely the situation that we have here. There are no documents.
We're out of time. We have
Thank you, Your Honor.
on the record. Thank you. You have a minute, sir?
I think the court, and it's appreciated, is a really hot bench, and I don't think anything is needed at this point.
Okay, that's our specialty. What we're known for. Thank you. Thank you for noticing. All right. MIC General Insurance versus Eckert. You may proceed.
Good afternoon, Your Honors. Michael Mernon from Hagel & Spencer for the plaintiff appellant, MIC General Insurance. In this case, MIC first obtained summary judgment below on a declaratory judgment action on the basis that the insured did not reside in the insured premises, and therefore there was no coverage for the underlying personal injury action that had been commenced.
But this is the case, right, where there was also a problem that neither lawyer for either of the Eckerts was there that day. Am I right?
That's correct, Your Honor. So here's how that played out, and I can tell you because I was there.
Okay. I wasn't.
The lawyer for the injured party was also active in the case. Ms. Pacheco Sanchez was present.
Yes.
I was present. We had the notice of the argument. The insured defendant, Mrs. Eckert, who's really the primary one.
Right.
George Eckert was just, a bystander to
Well, it was her husband's,
Yeah. But I mean, her attorneys were the ones who briefed it, and, we expected them at oral argument. If my memory serves, I believe the oral argument was virtual, and so we waited.
Yes.
We attempted to reach out, and
That's what I could tell from the record.
and honestly, as I stood there, I kind of anticipated that the trial court would adjourn it and try to reschedule. The court went forward with argument, was fully briefed on the issues. The court then ruled from the bench, and the transcript's in the record, I'm sure you looked at it, and said, I'm granting this on two bases. One is the default in not appearing for the oral argument.
Right. And one was
And then on the merits, and then proceeded to explain for about 3 pages all the merits. And I was happy to get the decision, so quickly, and then defense moved. So I'm just reciting procedure at this point.
Right. Well, so counsel, before you move beyond that point, I noticed in your brief that you didn't really fully address the excusable default portion of it. I mean, you focused a lot on the merits.
Right. So how I would put it, Your Honor, standing before you today, is that it's a red herring, because the ruling was on the merits, and the trial court in its revisiting and reversal of its first decision, I think was kind of trying to have it both ways in saying, notably, I'm not granting this on renewal re-argument. It's to vacate the default.
Right.
But you reached all the issues, and then uses the vacated default to issue an order that's a re-argument order, which the court isn't supposed to be able to do. And all the issues were fully
You also
briefed.
shouldn't grant something on default and then reach the merits. You can't, you do one or the other.
Right.
Okay, so that created the kind of platform for exactly what happened.
And I think the way I would put it is that the courts, if we call it a mistake in using both avenues, the punishment for that shouldn't be visited upon us. What should have happened, I guess, is well, an adjournment would have been ideal, but putting that aside, is
that ship has sailed.
For the judge to say, I'm not going to renew re-argue, because that, and I ruled on the merits, and then it's up to defendants to decide in their appeal. Changes the posture of the case, but we shouldn't be the ones punished.
Except they still have a decision that says on default and, oh, by the way, on the merits too. That's a problem.
Right.
That's a problem. From their perspective, hit me one way or the other, but don't hit me both ways, right?
Right.
So they get hit both ways, and I certainly understand why they would want to vacate the default, and then let's dance all over again.
I guess my point is, we believe the appropriate remedy, if at that moment, is for the court to say, I'm not vacating the default because I ruled on the merits, and then let, again, defendant take up the question of, we'll proceed with an appeal on the merits.
I'm not vacating the default because I did it on the merits. It's one or the other.
I take your point.
So it's not your fault that you were placed in that position, but we are now stuck with what happened. But we'll hear you on rebuttal, okay?
Okay, great.
All right.
Good afternoon, Your Honors, and may it please the court. Ross Frisha for the defendant respondent, Pacheco Sanchez. As Justice Pittberg correctly pointed out, the insurer does not dispute that defendant Eckert established a reasonable excuse or a meritorious defense for vacatur. The insurer also does not dispute that it failed to annex a complete copy of the operative relevant policy to its papers. And it doesn't dispute that the policy annexed was unsigned. It doesn't dispute that that policy was missing the crucial declarations page, and so on and so forth. It doesn't dispute the heart of the summary judgment decision here. Instead, what this appeal concerns, as Your Honors pointed out correctly, is whether the motion court was allowed to reconsider its earlier SJ order upon vacatur because it was rendered partially on the merits. And in this case, like you said, Justice Manzanet Daniels, we were put in a little bit of a strange position, but that's why the defendant Eckert moved under CPLR 2221 as well as under vacatur. So additionally, the insurer does not cite any case that stands for the proposition that upon vacatur through 5015 that the motion court may not then revisit the order that was issued on default, which is exactly what happened here and exactly what the motion court said. In any event, the second issue of this appeal is whether the motion court erred in denying the insurer's renewal motion. With respect to that, the insurer's argument that it is entitled to renewal based on the Eckert affidavit from the other action is completely devoid of merit because the motion court had considered that fact.
So am I correct? It was Mrs. Eckert who moved to vacate the first decision, right?
Yes.
But her lawyers are not involved in this appeal. Just you are involved.
So Ms. Eckert submitted a letter to the court adopting our position in this case. So that's why I would say that. But also, to go forward on the renewal point, the motion court, again, already considered the fact that Ms. Eckert did not consider herself to reside with Mr. Eckert, and in any event, held that that what she understands the term reside to be is not the dispositive question here. It's what the policy defines.
And it
wasn't. It's not defined, right?
It's
It wasn't
completely
defined in the
undefined.
policy.
Yes, it's not defined in the policy. It's not defined in the declarations page, which is missing. And in fact, the policy that was annexed was not in effect at the time of the accident.
Can someone have more than one residence for insurance purposes?
Can someone have more than one residence? Yes, yeah. You can get multiple insurance policies for multiple residences, and depending on what the term reside is meant to be, and if you look at the other terms in the policy that were provided, you see there's an extensive list of all these stipulations. It's not just a colloquial term. So I would say in that vein, then yes. And in this case, there is a very good chance that Ms. Eckert could have been considered to have resided at the...
Does the language of the policy say that it had to be her primary residence or a residence?
It just said residence, Your Honor, and it said that that term reside was to be in the declarations page of the policy. So there is no way that the insurer would have been able to meet its burden if that decision wasn't on default. So that's where it comes down to.
And there's no problem because it was on default, but it was also on the merits, which is sort of an odd thing, but that's what it is. That's what we have. We don't make up the facts. They come to us as they are.
Yeah, I think the defendant covered all of its bases to the extent that it could in moving under 5015 and CPLR 2221, while the motion court ruled on 5015 and then moved to to reconsider its other decision. The defendant did absolutely all it could in this situation. And so we would ask that Your Honors uphold that decision. Thank you very much.
You have 1 minute.
If I may, very quickly. First, it's stated in the brief and again by counsel that we do not dispute their merits defense. We explicitly dispute the merits defense and recite why our understanding is that, this reside and live, for lack of a better phrase, is dancing on the head of a pin. The case law is replete, and we cited cases about, where courts again and again have found no insurance because of the use of this precise provision. Two, the court...
In those cases, was the term defined in the insurance policy?
No, generally not. It's rarely defined. It's because it's common parlance. There's sort of a plain language aspect to what does reside mean. For instance, in Ms. Eckert's affidavit, I never lived there.
Except that you can own several pieces of property, not rent them out. So are you considered, if I own a house upstate by the lake, I'm hardly ever there.
Your Honor, that's an underwriting matter that you reveal upon your application for the insurance, and the insurance company makes an appropriate decision about how to rate your premium. That's not an issue. That's getting into the weeds. That's not part of this case. Those types of
We decide what's a part of this.
consideration, but those are that's red herring. The policy issues were dealt with by the judge in his first decision, and in his revisiting, he didn't rely on these issues about, there's no deck page, there's no that. And when he talked about there being ambiguity to reside and no definition, he cited to one case. That case, Tower v. Dean, is a case about a family that was building a house or doing extensive renovation, had bought it and not moved in. It was, do we live there yet or not? It was not a question about what does reside mean. It was that they hadn't moved in and they suffered a fire and they were trying to collect.
Thank you.
Thanks.
Romansky versus 300-302 East 119th Street.
Good afternoon, Your Honors. May it please the court. Lawrence Omansky on behalf of my daughter, Eve Omansky. In this case, there are three causes of action. One is breach of contract, and according to the proprietary lease and the bylaws under Section 103 and under bylaws Section 5 and 6, every shareholder has the right to financials, the tax returns, and to the board of directors meetings. These are sort of like the Bill of Rights, the constitutional rights for all shareholders, which the Attorney General makes sure that shareholders are informed of what's going on in their corporation. In this instance, my daughter found a potential purchaser, and the purchaser, as custom and usage in the real estate trade, was doing due diligence before signing a contract.
Did she provide the necessary documents to establish that this prospective buyer could have purchased the apartment unit under the, because it's a special HDFC unit, so there were certain requirements that maybe other co-ops or apartments didn't have. Did she ever put that forth?
No, and for the major reason, she didn't have a contract. Until the attorney did due diligence and signed the contract, she couldn't go forward. So she was applying as a shareholder. As a shareholder, she doesn't have to meet any requirements other than she's a shareholder. And as a shareholder, she was requesting these things, which included the board of directors minutes. The board of directors minutes are essential for any potential purchaser because that reveals whether or not there are any assessments forthcoming, whether or not there's any renovations, and what's going on in the corporation. To deny those rights and to deny the board of directors minutes was a breach of contract. Straightforward, there is no issues or arguments which defense can bring forth over why they didn't tender the board of director minutes. And second is the
Is there a particular time frame in which the board has to comply with such a request?
yes, it says a reasonable time. A reasonable time under reasonable man rules would be somewhere around a week or 2 weeks since the
Where'd you pull that out of?
I'm a reasonable man.
Reasonable man rules.
I'm reasonable. I'm a
That's
reasonable
funny.
man.
Okay.
All right. Anyway, with regards to that, it was clear since
I mean, there has to be some framework.
it says
right?
reasonable.
Okay, I heard you.
Okay.
So, but to you, reasonable is a week or 2 weeks. That may not be reasonable to a board who perhaps meets once a month.
That's correct.
So
That's why
if your request comes the day after we met, I don't meet again for a month, why would it be unreasonable for the board to say, okay, we'll take a look at your request at the next board meeting?
because
Is that unreasonable?
no, but
Okay.
the notices for
How
requests
much
for
time
review.
went by here?
What's that?
How much time went by here?
About 100 days.
Okay, so that's,
Right? We started on December 15th.
okay.
As of January 10th, we served the time of the
Well, I
essence.
mean, when you start something on December 15th, we only got Christmas,
No,
New
5th,
Year's.
December 5th.
December 5th?
December 5th.
Okay, I thought you
Right,
said
up
December
to-
15th.
Up to January 10th, at which time We sent the time of the essence notifying them, look, if we didn't get this, we would lose our buyer. And
But they're saying I get that, but I still don't understand how we knew that this buyer would have been an acceptable buyer.
it doesn't matter because she's requesting as a shareholder. All of those contingencies goes once a contract is signed. You can't add those contingencies and you can't meet those contingencies if you
So
don't
how
have
do
a
we know
contract.
if how do we know if she suffered any damages by losing this potential buyer because there was no proof that this potential buyer was an eligible buyer that could have purchased under the requirements, separate and apart from this issue you're talking about with the books and records?
Because it's irrelevant. If
How could
I,
that be
as a
irrelevant?
shareholder,
Counsel,
if I
it's
as
not
a-
irrelevant.
It is,
okay?
because if I, as a shareholder, want these documents, why aren't I entitled to them? Why do I have to show a purchase agreement first? Why do I have to show that they have affordability? It is my constitutional right there
Your
to have.
constitutional right. Really?
As
Your constitutional right on a proprietary contract. Come on.
Yeah, because.
All right, we'll hear you on rebuttal.
What?
Your time is up. You may proceed.
Thank you, Your Honor. May it please the court, my name is Jeffrey Rubenstein. I represent the respondent in this case.
Why did it take so long to respond to a simple request for minutes?
Your Honor, it didn't take long. It took a week.
100 days?
No, that's factually inaccurate, Your Honor. And if we look at Judge Crawford's decision, we can parse that and we can prove that.
Okay.
So the record indicates that the request for the financials was made on December 21st, and the disclosure of the financials was made to plaintiff on December 27th. That was a week gap with, as Your Honor knows, encompasses Christmas. That's with regard to the financial records. And the minutes were disclosed on February 7th, 2023.
Why did those take so long?
Similar to what Your Honor said, which is that obviously they meet monthly, so that's part of it. The other reason, Your Honor, is that these, and this is listed in the affidavit by Ms. Felix, the minutes are available on site at all times. So had the plaintiff been living in the unit, plaintiff could have accessed these records at any point in time and seen the minutes to the meetings.
She could make an appointment with the man and go down to the office and look at it?
Exactly. That's exactly right. So the duration to February is of the plaintiff's making because the plaintiff isn't living at the building. Plaintiff lives at the building, she goes to the office, and she sees those meeting minutes perhaps, within, I don't want to say instantaneously because that's an overstatement, but very, very soon thereafter upon arriving at the office. And because of those 2 points, and Judge Crawford ruled in this manner, there was no breach of contract and the matter was to be dismissed, and it should be dismissed. And the entire dismissal should be held up by this body. Quickly, because I have less than a minute, there were no wrongful means.
You have 149.
Okay, I'll slow down then. So there's the second cause of action for tortious interference with business relations. That is clearly inapplicable because there is not a scintilla of an allegation even in the complaint or in Ms. Omansky's affidavit in the summary judgment that there was any sort of violence or wrongful means, which is the linchpin of a tortious interference with business relations. So that second cause of action, which counsel didn't get to, should remain dismissed. And thirdly, the fraud cause of action is laid out chapter and verse by Judge Crawford. There was no detrimental reliance, and more importantly, there was no misrepresentation, so there was nothing to be detrimentally relied on. One thing I want to press upon, and Judge Kapnick, you mentioned this, which is that the buyer was never presented to meet the requirements of Public Housing Law 576, but moreover, Judge, as a predicate to that, and this is listed in the affidavit by Gail Felix, the plaintiff didn't comply with the co-op rules in listing the unit in the first place. And compliance with listing the unit in the first place takes care of these requirements that the plaintiff is saying is breached. So I would just put a special point on the fact that the property wasn't even listed in compliance with the unit's guidelines. Moreover, there is no signed contract between Ms. Omansky and a prospective third-party buyer anywhere in the record. So there was no imminent purchase. There was none of that. And
Certainly none that was presented to your client.
absolutely not. And so for that reason, all three causes of action in this matter should remain dismissed. And I thank the court for its time with regard to this matter.
Thank you. You have 3 minutes.
May it please the court, Anthony Petruzzi on behalf of respondents, HSC Management Corp. And Gina Torres. Your Honors, I won't spend too long re-arguing what counsel had just argued. Our arguments are the same. I just would like to touch upon one point specifically with the breach of contract claim. Appellant admitted in its papers its affirmation in its affirmation in opposition to our respondents' motion for summary judgment that these specific respondents are not guilty of, or they're not being claimed to be guilty of breach of contract. They're not signatories to the bylaws or the proprietary lease. So those are the only two contracts or agreements specifically identified. But Your Honors, if there's no other questions, I'll rest on my brief. Thank you.
You have 2 minutes.
With regards to the tortious interference and the claims that they performed according to the proprietary leases, it's clear, first off, that they were aware under an tortious interference with business relations, opportunity for relations, that was clearly the emails, the request for the minutes and the other documents was all making them aware of the listing and the fact that we were attempting to sell, all right? Defendant knew and intentionally interfered in the fact that they had the opportunity on December 27th when they served the financials and they served tax returns and a few other documents. At that point in time, on December 27th, they had ample opportunity to include the Board of Directors minutes, and they specifically and intentionally did not.
What about counsel's argument that your client could get those minutes very easily, just going to the office?
That's totally not true. If you look at the letter from December 22nd sent by management company, it specifically said, we are aware of the fact that you've requested these things. It's subject to the board approval. Until the board approves it, we will not give you those. So the claim that we could go in any time if we were living there was totally untrue. All right? And the fact of the matter was that they knew that if they did this and they withheld the Board of Directors minutes, this would terminate the agreement, the negotiations. And it was clear that this is a wrongful means to say that we're not going to give you these Board of Directors minutes. All right? They had every obligation to. They had ample time to. They served it on 12/27, they served the financials and other documents, and there was no reason they should not have included the Board of Directors minutes. Instead, they intentionally did not give that, knowing on the January 10th, there was a letter saying time of the essence, enough of this. They saw that letter.
What was the time of the essence? That was
That they said
for
that
what?
if we don't get the Board of Directors minutes, then the contract's going to be terminated. And on January
I thought you said there was no contract.
the negotiation, sorry, the negotiation. And they keep arguing as if there was a contract. There was no contract. So there couldn't have been a breach of contract. It was a breach of negotiation, business negotiation. No negotiations with the signing of the contract. And the attorney for the purchaser had every right to due diligence, and it was clearly their responsibility to turn over these documents. They didn't. He lost, my client lost the sale, which was over $250,000, in addition to all the expenses carrying the maintenance and everything. And for these reasons, I believe that they have violated tortious interference.
Thank you so much. People versus Emmanuel Ford. may proceed.
Thank you, Your Honor. Nicholas Luongo from Latham and Watkins, pro bono appellate counsel for Mr. Emmanuel Ford. The burden is on the prosecution to show good cause for why it took 3.5 years to prosecute Mr. Ford, where he was captured all over multiple surveillance videos, multiple police officers.
Counsel, but you still need someone to identify him, right?
Not so, Your Honor. In fact,
the video's enough?
At trial, the default is that the jury is just as able as anyone else to see a defendant and decide.
Right, to evaluate testimony, but you just can't put, are you saying that you could just put the video in front of the jury and say, is it the defendant? You figure it out without anything else?
Absolutely, Your Honor, because
Really? You need a witness for the video. So who is presenting this video and they are testifying to what?
well, the foundation is absolutely acceptable. So if you want to have an officer come and say, this is where we collected the videos from, these are authentic videos, I think
And
that's,
you figure it out, jury?
I think that.
What case allows a video without some witness pointing to what this video represents?
Okay.
Right?
I had read cases like Mosley or Coleman, which Your Honor knows well. You were on that panel where I had read that to indicate that usually you can't have a detective come and identify a defendant on video.
Where there's a basis for their knowledge, you can. That's why you put the detective on, right? And in this particular case, when the detective, I observed the video, the people felt that he didn't have enough foundation to then become a witness. That happened after years, well, I guess it was 3 years, he had more interactions with him, and I think this goes in lines with the cases that you're talking about. He had more interactions with him, and then therefore became a more reliable witness, so to speak?
Your Honor, that's their argument. I think there's one, good reasons to be skeptical about whether that's what happened, and two, even if it is, the obligation is to investigate and take affirmative steps to bring him to trial, right? You may think, okay, we don't have enough evidence yet. But if
What else could they have done if this is their witness who's going to identify this person based upon the video, and they don't have enough information at that time to get a conviction beyond a reasonable doubt, at least in their evaluation of the case?
Yeah, other than the defendant who did the actual shooting.
Right. Well,
testifying against your client, what else? Who else were they going to get information from?
One thing I'd like to
No, answer my question.
This is the answer. There were apparently multiple officers who immediately recognized and had interactions with the defendant before and after. And those multiple officers were never explained because prosecution and respondent has only focused on one detective, Daniel Wadolowski. But even if we focus only on Detective Wadolowski, he had already known Mr. Ford for between 2.5 and 4 years. And so he knew exactly where Mr. Ford was and where he could gain necessary familiarity. Just the way he did over
well, the familiarity
the next
has to
2.5 years or
come.
3.5 years.
The familiarity has to come prior to him actually viewing the video. It's not something that he can, work backwards from. So, but what is wrong with the people after they speak to this detective saying, we don't have enough, we're not going to make an arrest, let's see if we can get more information and investigate more?
I think there's nothing wrong with that. What's wrong is that they closed the investigation. They didn't investigate. They took 0 steps, and in their brief here, they say, well, there's absolutely nothing we could do. But look, with the co-defendant, they used that same video footage to get a search warrant and go and find corroborating, like the clothes he was wearing. And now they say, oh, he's wearing an undershirt, but he's wearing other clothes.
Presumably they had an identification to do that.
I'm sorry?
Presumably they had an identification, or at least a legally proper identification to get the search warrant.
Their identification for Detective Allen, or for the co-defendant Allen, was Detective Jeffries, who had similarly seen Allen on the street and talked to him for, they said, several or 30 minutes.
So if this had been a cold case where they had the video, but they had no one to identify anyone in that video, would this still be a problem?
If there were a cold case, I think the difference would be that in a cold case, police
They
don't have
had no
control.
lead.
they can't do anything about it. But here, they can at least take some steps, right? And
Like what?
that's what divide.
Like what?
Like go and say, hey, Mr. Ford, could we talk to you for 15 minutes?
Mr. Who?
That's enough for Detective
the
Jeffries. It should
defendant?
be enough for Detective Wadolowski. They have an obligation to at least try.
Okay.
Thank you.
All right.
Good afternoon, Your Honors. Jacob Marcus for the
So
people.
what did you do for 3 years?
So for 3 years, there was not active investigation on this case.
Well, that's different from the cases that we have, that we're talking about Reagan, Wall, Tyson. These cases have different factors where somebody was actually doing something in 3 years, or maybe not in Reagan, but doing something for 3 years.
I don't think that's quite right. I'll point to one offhand. People v. Rodriguez was one where the people made a determination, I think they say a legitimate determination that they couldn't proceed on the evidence they had, and then ultimately they just changed their minds. That wasn't even like in this case where there was acquisition of new evidence 3 years later.
Evidence.
Is that the surveillance
What's
video?
the new evidence?
The new evidence it's two things. First, it's the discovery of the Tech 9 after the 2021 shooting, this distinctive gun with a foot-long ammunition barrel. And then the second one was after the police discovered the Tech 9, they reopened the case, they bring it to our office, and then we speak to Detective Wadolowski and then make the determination that he has a comparatively sounder basis to offer a Coleman Mosley identification at trial. So in 2018...
Was there another surveillance video in 2021?
There was not new surveillance video of the 2018 incident.
I meant another 2021 surveillance video that
Yes.
had...
The 2021 shooting incident, which to be clear, defendant was not a perpetrator of, that was captured on high definition video. So that's why his involvement in that shooting was really beyond dispute. So I think there we have, in 2018, we have the grainy surveillance video from 2018. In 2021, we have the 2018 video, Wadolowski's identification, and the Tech 9 that links defendant to 2021 as the shooter's accomplice in 2018. So I think proceeding based on 3 things versus 1 is certainly a change in circumstances. In terms of defendants' allegations that we do have this obligation to continue to investigate the case, I don't think that's right because, as Your Honors alluded to, by that logic, we could never prosecute a cold case unless we had been checking in on the case every single month.
A cold case is different. A cold case means you have no leads. So you have to wait until something kind of happens and drops out of the sky that opens it up. Here, you had an officer who thought he could identify this defendant. So there was something.
Well, I don't know if there's an
That's not a cold case. He has something.
Your Honor, I don't think that that's an investigative lead because the people made the determination that if we tried to move forward on that identification, it wouldn't be admissible at trial.
I mean, but it's almost as if you're arguing that there's no one else in this world that could identify this individual other than this detective. And so you're just going to sit and wait for 3 years and hope that he commits another crime. And now that now you have something to move forward on. I mean, at what point does that not become like some kind of unreasonable delay?
Well, Your Honor, I do think it's worth noting that as defense counsel conceded in their papers below, this crime was thoroughly investigated. We did perform an exhaustive video canvass of the area. We spoke to the witnesses, got their contact information, and then, of course, we gathered enough evidence to charge and ultimately convict Allen. But to Your Honor's point, I don't think this is a case like Regan, where there's one glaringly obvious, easy lead to follow. There, in a rape case, there was semen discovered in the victim's underpants, and we didn't get a buccal swab warrant because, as the prosecution admitted, I say we, meaning the people, this wasn't our office, as the people admitted, they just didn't know how to. It was incompetence. This court has previously distinguished Regan on that basis. Here, where the police investigated it, they investigated it thoroughly, and then they determined there wasn't evidence to indict or to convict defendant at trial, only Allen. I think it was a reasonable exercise of prosecutorial discretion not to charge him.
And the prosecutor's goal is I mean, if you're going to bring a case to trial, it's to gain a conviction at trial beyond a reasonable doubt, right? Not to establish what you need probable cause to get an arrest.
Exactly, and I think that highlights 2 things. First, as the Court of Appeals acknowledged in Vernace, time cuts against both sides. So it's not like it's in the people's interest to delay these cases. We have an interest in prompt prosecution as much as the defendant does. But more than that, I think that it's worth noting that in the Court of Appeals' recent decision just a few weeks ago in People v. Tyson, I submitted this via NICIF. I have hard copies if your honors would like them. In People v. Tyson, the court emphasized that the prosecution should not indict just because we have a reasonable cause. We should only publicly accuse someone of a crime and subject them to pretrial detention if we are confident that we can actually convict them at trial. Here, we made a reasonable determination to exercise a prosecutorial discretion and not publicly accuse someone of a crime. And on that basis, on the balance of all 5 Taranovich factors, I'll note that 3 and 4 also cut in our favor. Your honors should affirm. Thank you.
Counsel, you have time on rebuttal.
So counsel, I just want to pick up that thread about this prosecutorial discretion, right? I mean, because wouldn't we as a society want the prosecutors to make sure that they have all of their ducks in a row before they go and publicly accuse someone, arrest them, subject them to pretrial detention?
I think that's absolutely right, Your Honor. And that's the right to prompt prosecution serves society, victims, and the public at large by encouraging the prosecution to promptly prosecute. And so I agree that prosecutors have to be careful, and a reasonable doubt is a high standard, but that's why you can't just close the case. That's why prosecutors need to take what
Counsel, what prejudice did the defendant suffer?
Well, he was charged with a specific intent crime where it matters what was said, right? And the exact conversations people were having when, whether he knew that Alan, who had just himself been shot and was drunk, was planning to murder someone. And that evidence was all lost.
Counsel, I understand you're doing this case pro bono.
Yes, Your Honor.
On behalf of this court and our system, I want to thank you.
Thank you.
For your service.
Thank you, Your Honor.
Danielle Whitley versus Lee.
All right, may it please the court. My name is Samantha Pullman for the appellant Kumo Sushi Lounge. I'll keep this very brief. I think it's a fairly straightforward case. The defendant driver, Mr. Lee, as you know, was operating a van at 10:30 at night at the Hutchinson Rivers Parkway, like he did on many occasions. No reasonable expectation that a person would be on that highway, certainly not darting in front of his van as he's traveling that night. I think the lower court got it wrong that there's some sort of question of fact whether Mr. Lee was negligent in his operation of the vehicle. He testified that he was traveling either at or under the speed limit. He said he was going 45 miles an hour. He believed the speed limit in that area is 45 to 50 miles an hour. When he first saw...
Also, there was some discrepancy as to, I don't want to say when, but how far away the person that was struck was when the driver first observed the person.
Sure.
And how does that play into the analysis here?
It does not play into the analysis. He was fairly consistent in his testimony that it was about 100 feet, but he's operating a van. And when he said, whether it's 100 feet, 200 feet, when he first saw this 12-year-old, I want to point that out, that it's not like a toddler on the side. It's a 12-year-old. That 12-year-old was standing still. And as he gets to, he said about 2 car lengths, that's when this 12-year-old started to make a move, and then he described it as like an athletic running position when it was 1 second before he got to this person. He took evasive actions of moving, and that's why the collision did happen to the right side of the van and the pedestrian. He didn't hit him full on because he did take evasive action to try to get into the left hand.
What the driver says was that when he sees the person, he takes his foot off the accelerator, starts merging left, right?
Yes.
And then the child darts out, according to the driver, and is struck. Is that right?
Correct.
Okay.
Well, he said when he first saw the child was standing still.
Right.
As he got closer, that's when the child started making these moves. And then when he said about 1 to 2 car lengths away from the child, that's when the child darted in front of his vehicle at 10:30 at night at the Hutchinson.
And just to make sure, the driver's not appealing, correct?
Correct, and I do not represent the driver. But yes, I also want to just point out that this was not a toddler. That's something that wasn't really brought up in the briefs, but unfortunate situation, but
Did you argue the emergency doctrine came into place in this case?
yes, we did. We argued that under these emergency circumstances, this driver, Mr. Lee, took every reasonable action with the circumstances he was presented with.
Did the court make some, the trial court or the motion court make some finding that because Mr. Lee may have had a little bit of trouble with the English language, that some of his testimony may have been a little confusing, and that may have created an issue of fact?
I believe there was some alluding to inconsistencies, but his testimony was consistent. And whether, when you're driving a van and someone darts in front of you, you're not necessarily keeping in track of how exactly close you are, but his testimony was when he first saw this child, the child was standing still. As he got closer, that's when, and by that time, there was really nothing he could do. He did take his foot off the brake. I know the lower court was harping on the fact he didn't honk his horn, but I'm not sure honking the horn. I think taking more of an evasive action was more beneficial here than honking a horn.
So here the child suffered catastrophic injuries and obviously is not able to provide his version. On the noseworthy, what effect does that have in this case?
What do you mean by that? That he can't?
He can't give his side.
I mean,
as a result of the injuries suffered because of the accident. It's not that he's not choosing to; it's that he can't.
Correct. I mean, our reply brief does address that. I don't think it's relevant here.
It's absolutely relevant. The question is, how do we manage it? It is absolutely on a relevant doctrine that if this case goes to trial, the court trying this case will have to contend with, and we'll have to charge the jury on.
Yeah, I mean, I just think it doesn't have any base in the fact that this child was still present on the highway, which was in violation of the law and the statute. So even
that doesn't absolve your client, right? I mean, even if the child, let's assume that the child was on the highway unlawfully, he has to see what's there to see. And he admits that he saw the child.
He saw the child not on the highway. He saw the child
off the side of the highway.
Side on a grassy median, not standing still.
Right.
So,
but be that as it may, we still have to grapple with that case, right, in which the victim here, because of the catastrophic injuries suffered as a result of this case, cannot put forward their side.
I just think that rule only applies when the plaintiff meets the burden of raising a tribal issue of fact, which I contend they did not in this case.
That's the whole point of noseworthy, that they can't. But you'll have time on rebuttal.
Okay. Thank you.
May it please the court, Jason Richmond on behalf of the respondent. Trial judges in Bronx County have a long and storied tradition of getting it right the first time. This is another example of that.
He did his homework.
He is
He did his homework.
You are shameless.
And in reply, the defendants appealing this decision cited extensively to the second department and not a single first department case. But that aside, we have absolutely inconsistent testimony from the defendant driver, who's the only witness we hear from in this he said, she said, but there's no she.
What's inconsistent about what the driver said?
First he says the kid was standing still. Then he testifies, record 288, that when I first saw him, he was only moving a little bit. And he says, when I first saw him, I knew something was wrong, but I didn't really do anything.
You know what? At 10:30 at night on the Hutchinson River Parkway, you see a kid on the side of the road, you know something's wrong.
I think that's true. And I think
so there's nothing strange about that.
What could he have
strange
done?
about that, but seeing a child
Counsel,
on the side of the road.
What would you say he should have done?
Slow down.
But
He took his foot off the gas.
Yeah.
I mean, there was like
slowing
1 or
down.
2 seconds.
At one point he says he took his foot off the gas, and at another point he said he didn't do that. He just started to move to the right. And
So both of those things are evasive maneuvers. He tried to do something. Either way, if he took his foot off the gas, he tried to slow down. If he went to the left, he tried to avoid the child.
I mean, he couldn't slam on his brakes driving on the Hutchinson River Parkway.
At 10:30 at night, he gave testimony that he wasn't even sure if there were any cars behind him.
Oh, come on. I'm on that sucker every day. Please, stop it.
It's what he testified.
Stop it.
I'm just
Stop
referring
it.
to the record
Stop it,
testimony.
Stop it, stop it.
This driver saw a child on the side of the road. He knew something was wrong, and he took insufficient action to try and protect the child from the collision.
What's he supposed to do?
Slow down more.
Slow
Turn
down
his vehicle to the right. He said he didn't want to move into the passing
He
lane,
said he had a second or two.
and he also said he's not familiar with the units of measure, and he may have those distances wrong.
Yeah, but you know what? But we in the courts know that there are formulas for figuring out what your stop distance is based on what your travel speed is and how much further your car is going to go even after you slam on the brakes.
Absolutely.
Right? So we know.
Absolutely
and based on this testimony, he didn't have enough time to do anything other than what he did.
That's not true. Your Honor, he absolutely testified that he saw the kid well enough in advance
100 feet.
that he said he wasn't sure about.
100 feet.
He said he wasn't sure about that unit of measure.
But even if it were 200 feet, that means he had 4 seconds.
How long does it take to go like this and avoid hitting a child?
He said he did that.
He did that.
testified that he did that.
At the time that the accident occurred, after he saw him and traveled up to where the child was, that's when he started to change lanes. And according to the testimony, he was starting to change lanes when the collision occurred. And the child didn't get to give his testimony, as the court has pointed out. So we have just the defendant's testimony to work with. And in this case, look, when you see a kid on the side of the road,
Tragic. Okay? It's tragic.
I agree.
You have a 12-year-old on a highway that he shouldn't be on by himself.
Of course not, but 1229 violation is not lexically prior to the legislature's requirement that 1146 is. Notwithstanding any other provision of law.
Driver's nightmare.
It is. Notwithstanding any other provision of law to the contrary, drivers shall use due care to avoid striking a child or striking a dog. And that's more important than a law that says stay in a crosswalk or don't cross at a non-intersection.
Very briefly, respondent's own brief cites to Mr. Lee's testimony, which supports what I've been saying, that he said, when I first saw him, he was standing still. So then when he moved, I tried to instinctively change the left lane. The left lanes were passing. That's irrelevant to my point. So I'll stop there. He took every evasive, appropriate action under the circumstances. As you pointed out, Your Honor, these are circumstances every driver cringes about, does not want, and certainly does not expect when traveling at 10:30 night on the Hutchinson Parkway. Whether Mr. Lee was in the right lane, left lane, this child clearly was darting in front of vehicles, and it's not fair to now these defendants.
The darting comes from the driver, right? And I don't know, we're sort of stuck with that because this kid, catastrophic injuries.
Correct, Your Honor, but I don't think this would have happened but for the child darting. I don't think he would have wandered. I don't know. You're correct. There's one testimony from what happened that night.
Thank you both.
Thank you.
No winners in this one. Forrester versus 640 Park Avenue, last but certainly not least. Oh, and Justice O'Neill Levy is recused on this case. Should we have a tie, we will employ our court's vouching in another judge. Okay?
May it please the court. Yes. Matthew Weineck for the plaintiff appellant, Corrine Forrester. Try to keep this brief as we're the last ones to get you home. Your Honors, there's two critical facts when viewed in the context of the timeline that show the respondent's participation in the discrimination that's alleged in the complaint. The seller says that he scrutinized Ms. Forrester's finances. He didn't do the same thing with respect to the white male buyer, Mr. Furman. Now, this unit sat on the market for 2 years unsold. Ms. Forrester comes in, she delivers $72,000 to the seller.
So I just want to ask you a quick question
Sure.
before. I'm sorry to interrupt you. The unit, does it have to be used for medical purposes, or can it be used as a residence? Is there any evidence of that?
The certificate of occupancy is for medical use only.
Only.
Medical use only.
So she delivers $72,000 to the seller. He's been trying to sell this unit all this time.
And
He
then the
gets
unit
money.
is sold to someone who's going to use it for non-medical purposes, as far as the record?
He's not a doctor. He's not a medical professional.
he
He's
can't
in the
use
finance
it. I mean,
industry.
he
cannot
can't
use
use
it
it.
for the intended purpose.
Unless he rents it out to somebody else.
Correct. If that's allowed. I'm not clear if that's allowed under.
That's the other thing, right? Okay.
So there's communication with the management agent, with the board.
Communication by whom? By you?
Communication by the seller.
By the
They know that he's trying to sell the unit for 2 years.
Because he makes an inquiry about whether she would qualify
Correct.
to use the unit, right?
Correct.
But without medical supervision, because she's a nurse practitioner and not a doctor.
Correct. Well, yes, and there was some question about that, and they sort that out. When he has this $72,000 in hand,
That's the down payment.
as a down payment, he reverses course. The seller says he didn't scrutinize the finances of the white male buyer, but pulls the deal with Ms. Forrester
Who was paying in cash?
in cash, and goes ahead and takes a leap of faith and sells to Mr. Furman. Now, I don't believe it was a leap of faith. I think the allegations support that he spoke to the board, he knew Furman would be approved, and that gives him the confidence to say, I'm not going to go ahead. So that shows their involvement, that shows their participation. It's not just...
What about for Brown Harris Stevens, because you're talking about the
management.
co-op, the 640 Park, so I hear what you're saying about that. I thought your complaint was a little light on these claims, but Brown Harris Stevens, how do they fit into this?
They're the management
They're the
company.
management.
They were involved in the communications concerning whether Ms. Forrester would qualify with her nurse practitioner license.
And you have documentation to support that correspondence that was had?
There's emails, yes.
That you put into the record?
Well, this is a motion to dismiss, so it's just on the complaint. They weren't submitted as part of the motion, but we have them.
All right, you'll have time on rebuttal.
Good afternoon, Your Honors. Christopher Midway of Coffin Knowledge.
So, Counsel, why isn't it enough to allege that the plaintiff with a cash purchase, who had discussed with the seller and basically almost approved, gave a down payment, using it for medical purposes, and then loses it to someone who is a non-medical professional who of a different race?
And a
Excellent
member
question.
of the board.
I'm sorry,
And a
Your
member
Honor.
of the board, yes.
Excellent question. And at the end of the
Kind
day,
of the heart of the issue, right?
and at the end of the day, we have no representation of this transaction on my clients. We have Brown Harris Stevens Residential Management, who confirmed in the affirmative that plaintiff could use this unit. There was no new conditions, nothing that said you can't use this unit. Go ahead, you've got our blessing as far as it's concerned. Plaintiff also sues the co-op board. The only allegation in the 76 paragraph complaint as to the, I'm sorry, this is 1 minute, as to the co-op board is that Glenn Furman, the purchaser, the ultimate purchaser, what happened to be a member of the board. There is nothing in the record that indicates there's any communication beyond rank.
Right, but who would have that information? Not the plaintiff.
And Your
That
Honor-
would come during discovery. It's enough to allege it at this stage.
And Your Honor, that's something that plaintiff has never raised. There was never a discovery issue at the trial level, in their appellate brief, in the reply brief, or now. They have, by all accounts, I think they've waived there any issues to discovery.
Trial level.
I'm sorry, their opposition to the motion to dismiss.
Okay, yeah, because we
Sorry,
haven't even
sorry.
had discovery. What are you
We don't have
talking
an
about?
answer. I mean, this is a pre-answer motion to dismiss, right?
And they certain.
And you can't sell, last time I checked, a co-op board has to approve a buyer. So this co-op board was fully aware of what was going on because they would have had to approve their own board members' purchase of this apartment,
Your Honor, there is
right?
correct.
Okay.
However, there is nothing in the record indicating the board was ever made
We
aware.
have nothing in the record.
Correct.
That's the point.
And
That is the point. So the question is, on this pre-pleading, right, pre-answer, motion to dismiss, are there enough allegations pled?
And I argue there are not enough allegations pled to get past that point. And I think the timeline is clear and the allegations are clear. It is against Defendant Tickener, who is the current trial court level is still ongoing. She still has a claim against him. And she actively has not chosen to sue the buyer, who she claims to be at the nexus of all of this.
But the buyer's a board member, like that, no one's disputing that.
No, there's no dispute there. He happened to be a board member.
Not that he happened to be, he is in fact.
I don't know if he still is, but
At that time, he was in fact.
yes, Your Honor.
Okay.
Yes.
Okay. You're out of time.
All right,
Have
thank you.
anything else you need to say since we hit you with so many questions? I want to give you an extra 30 seconds if you need it.
I reserve it.
No, this is it. You got to do it now. Okay.
Unless there's any further questions, Your Honors, I'll rest on our briefing.
Thank you. Have a good day.